All rise. All persons having business for the Honorable Chief Judge and the Associate Judge, double time over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and its honorable court. Its honorable court is now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We apologize for our delay getting started this morning. We have 3 cases to be heard this morning. The first case is in re T.J. Jr. DT appellant. In re D.O.J. DT appellant. In re D.A.J. DT appellant. In re D.E.J. DT appellant, T.J. Jr. appellant, D.O.J. T.J. appellant, appellee, and D.A.J. and D.E.J. appellant. So we have a consolidated case. We have, because these are consolidated cases, several parties arguing, and so I wanted to just clarify my understanding of the time allocations, and you all can correct us if I'm not understanding it. Appellant DT, Counsel Sabine Brown, will have 15 minutes to argue, and you can request some of that time be reserved for rebuttal. Appellant TJ, Counsel Allison Bauer, you'll have 15 minutes to argue, and you can request to reserve some of that time for rebuttal. The appellee, guardian ad litem, Counsel Catherine, is it Pickett or Pickett-Took? Pickett-Took, will share 15 minutes of the district's time and will argue before the district. And then District Counsel Pamela Soncini will argue the remaining time. How would you like to split up the appellee's time on argument? Okay. All right. With that, are the parties ready to proceed? Yes. Okay, and I would just note for those watching the arguments that are being live streamed, all those parties present in the courtroom are asked to keep your mask on during the argument unless you're speaking. And when you're speaking, you have the option to remove the mask if you choose or not. We've elected to remove our mask just so you can see more easily which of us is asking the questions during the argument.
Good morning. May it please the court. My name is Allison Bauer, and I represent the appellant T.J. Sr., who is the biological father of D.O.J, D.A.J, T.J. Jr., and D.E.J. I request to reserve 3 minutes for rebuttal.
All right, thank you.
Appellant T.J. Sr. is requesting the court to reverse and vacate the magistrate's December 14, 2021 order.
Counsel, I didn't mean to interrupt, but could I ask you to talk a little louder or move the microphone a little closer? Just.
If I may assist you in one respect, I think you can raise the lectern to move the microphone closer to you.
Yeah, I think that's the high.
Okay.
Okay.
All right. Appellant T.J. Sr. is requesting the court to reverse and vacate the magistrate's December 14th, 2021 order, January 11th, 2022 order, and corresponding December 21st, 2021 clarifying order, changing the respondent's permanency goals from reunification to adoption without an evidentiary hearing. And we are also asking that the court order an evidentiary hearing to be held in the above captioned matter. The appellant asserts that the court committed legal error by concluding that in re TAL does not apply to cases with no reasonable efforts required based on aggravated circumstances. Findings to include cases where the permanency goal at the disposition hearing was set as reunification with a parent.
Can I ask just a basic nomenclature question. Everyone's talking about aggravated circumstances, but I don't see that term in the statute. Am I missing it? Or is that just the accepted way that we refer to factors C and D under DC Code 4-1301.09A subsection C? No, yeah, C and D.
So yes, that is a colloquial term. There are a list of circumstances listed under 4-1301.09AD. And
Sorry, yes.
in those, if those set of circumstances are present in a case, then the district would ask the court to make a no reasonable efforts due to aggravated circumstances finding. And so
So that's
it's
just
become
the
the short
parlance
term.
of Superior Court. We call that aggravated circumstances, but it's not statutorily based.
That's correct.
So the statute says that the district shall not be required
Correct.
to make reasonable efforts. If you hold a TAL hearing and the trial court says, well, I disagree with the district, I think that the goal should remain reunification. Is the court empowered to require, or is the district obligated, despite its view, to make reasonable efforts? It seems like the statute precludes that. The court can't order the district to make reasonable efforts. How do you respond to that?
Yes, so that is the argument of the district, and that was also highlighted in Magistrate Judge Albert's December 21st, 2021 clarifying order. And my response would be, if you look at the statute 4-1301.09A, and essentially, if there are these circumstances outlined under 4-1301.09AD, two actions are triggered. The first is that no reasonable efforts shall be required by the agency towards reunification. And the second is that a permanency hearing must be conducted pursuant to 162323 within 30 days. So then if you look at the statute, DC Code 162323, in the timing section of that statute, it highlights that it does mention 4-1301.09AD and indicates that permanency hearing must be held within 30 days in this particular circumstance. However, if you look at 162323C, which states the purpose of a permanency hearing, it states that a permanency hearing shall include determining the permanency plan for the child, including a return to a parent, as one of the permanency plan options.
So you're reading the intersection of all those statutes essentially as the reason of any obligation on the district to cease or suspend reasonable efforts is really only viable during that 30-day period when you are waiting to hold the permanency hearing.
That's one possible interpretation, yes. I would also note that I assert that these statutes are ambiguous, and that because of this ambiguity, you have to take these statutes and read them in light of the context of all neglect statutes.
So let me ask an example. Here, the aggravated circumstances finding was due to allegations of abuse against another child of the father that the mother here was the legal guardian of, who's not a part of this consolidated neglect case. So if the district were, say, providing reasonable efforts like drug treatment, parenting classes, upon their request to trigger their aggravated circumstances provision, I'm going to ask the district this question too, but they seem to be suggesting that they would stop, full stop, no drug treatment, no parenting classes, no nothing. because of the aggravated circumstances finding. Your view is what? That there's nothing that requires them or allows them to cease reasonable efforts upon a finding of aggravated circumstances?
My view is in this particular circumstance where the goal was set at disposition as reunification. And the court is moving to, the government is moving to change that goal to adoption. And that the aggravated circumstances finding was made December 14th, 2021, whereas well after the goal was set as reunification, that if an evidentiary hearing was held pursuant to INRITEL, the government could raise that potentially of a lack of efforts towards reunification post December 14th, 2021 as a kind of affirmative defense. But they would still have to prove that they complied with the court order prior to that time period and that they made reasonable efforts towards reunification.
So your interpretation then would be that any requirement that the government is reading into this that would allow them to cease reasonable efforts upon an aggravated circumstance finding, they couldn't cease doing that until after the TAL hearing 30 days after they trigger the aggravating circumstances provision.
They could argue and raise that as affirmative defense. I don't know how the trial court would proceed, but I think they would have that option. I also think
I'm having a little trouble following your reasoning. The purpose of a TAL due process hearing, isn't it to determine whether the district government should be making reasonable efforts to achieve reunification?
well,
That's the whole point of the TAL hearing, is it not?
I would
And if
respectfully,
the statute says you do not have to make those efforts if the parents committed the kinds of abuse referred to in the statute that specifically says you shall not have to make those efforts, where are we?
yes, well, I would assert that the government would still have to present evidence that there was a reasonable plan toward reunification in this matter because the goal was set as reunification at the disposition.
I'm sorry, I lost you, because why?
The goal, apologize, I'll speak up. The permanency goal was set as reunification for a substantial time period in this manner.
Well, what difference does what happened in the past make? At the question is at the TAL, at the time of the TAL hearing, the government comes in and says, here's our statute. Here's what these parents did. Because of what they did, we are not required. We shall not be, Judge, required to make reunification efforts. And we don't want to. End of story. Now, it's true, they could. The fact that they shall not be required doesn't mean they can't if they don't want to, if they want to. But if they come in and say, well, we don't want to, that's the end, isn't it?
Well, I do
Or if
think,
it's not, explain to me why not.
I do think INRITEL emphasized that the change of the goal to adoption is what begins the path to effectively severing the parent-child relationship, which is.
Excuse me, again, I've lost you
protected.
because you're not speaking loud enough. I apologize.
I apologize. INRITEL emphasized that the change of a goal to adoption is what begins the path of effectively severing the parent-child relationship, which is constitutionally protected. And that's why the Court of Appeals indicated that these decisions are so important as to be appealable. And yes, even where a parent is found to have aggravated circumstances, that parent still has parental rights intact. As to the respondents who are the subjects of an open neglect case, and therefore the court should hold an evidentiary hearing with the heightened due process rights it affords for the this parent-child relationship that is intact.
What do you, at the TAL hearing you envision
Yes.
in a circumstance where the statute says the district shall not be required to make reasonable efforts? What do you envision being disputed at that TAL hearing?
Well, it would afford both all the parties an opportunity to present evidence as to whether or not the parents have made progress toward ameliorating the conditions of neglect. And the parents could also present evidence of any reason they see
And
fit to
and why is
continue.
that? Suppose the parents bring forward such evidence. They say, we've done done various things. We've entered into programs, we've done this. What then happens at the TAL hearing, in your view?
So if I understand
And
your
the
question,
district says, well, that's all very interesting, good luck, but we're not interested in making in reasonable efforts to support reunification. What happens?
right. Well, I would argue that the statutory interpretation doesn't, when taken as a whole and read in the context of all the neglect statutes, doesn't support this interpretation, the strict interpretation of
Doesn't support,
this strict interpretation that the court lacks all discretion to set a permanency goal of reunification after.
Right, I mean,
Aggravated circumstances.
isn't that the point that a TAL hearing, it's not a reasonable efforts hearing, although reasonable efforts is one of the things that a court looks at in determining whether the goal should be changed. It's a permanency goal hearing. So the ultimate question is whether or not the permanency goal should be changed, right? And lots of things go into that. And we said that in TAL. We said the primary focus of the permanency planning hearing should be on the parents' efforts to ameliorate the conditions that led to neglect and the district's efforts to assist them in achieving those goals. So sure, reasonable efforts is a big part of a TAL hearing, but it's not the whole enchilada, right? You're looking at what the parents are doing, right? So later on, we say, at an appropriate hearing, will provide the forum where the parents can testify under oath concerning any alleged failure on the district's part to provide the requisite services and resources, as well as their own efforts to meet the goals set forth in the plan that was developed to promote reunification, right? It is an opportunity to decide, what are we doing here, right? And so reasonable efforts is a big part, but it's not the sole inquiry of a permanency goal hearing that
well, you're
is
shaking your
required
head,
under
yes,
TAL.
but I'm just trying to get a sense of what happens as a result of that. Suppose the judge says, these parents are making tremendous strides. I'm not changing the goal. I think the goal should remain reunification. Okay, the judge says that. And so what is the consequence of that?
So the consequence would be two
It certainly does
possibilities.
not, I mean, the reason I ask is, I'm just trying to understand what it is the fight is really about here. Because if it's true that the judge cannot require the district to provide reunification services that it does not want to require, then it sounds like the determination, the judge's view, that the goal should remain reunification is of no particular consequence, because it doesn't stop anybody from pursuing adoption, or for that matter, any other alternative, but it doesn't stop anybody from pursuing adoption. It doesn't stop somebody from petitioning to adopt the children and to terminate the parents' rights. I'm just trying to understand what you think is the consequence if the judge says, well, I don't agree with the district. I think reunification should remain the goal, despite what the parents did.
Right. I suppose my argument is I disagree with your premise that the 4130109A-D strips the court of any ability to order a permanency goal of reunification after an aggravated circumstances finding.
What can you point us to? Because I think, for example, New York statutes, New Jersey statutes seem to be a little clearer in this area, that if there are aggravated circumstances, you get to a TAL permanency hearing, and the judge, after hearing testimony from the parents and from the state or the county government, still thinks that reunification is possible, the judge has discretion, or it's clearer in some other statutes that the judge has discretion and the ability to require reasonable efforts. Is that what you're saying here? What are we, you don't read the statute as stripping the court of discretion to order ongoing reasonable efforts if there's a determination by the court that reunification should still be the goal. Is that correct?
That is correct.
So what part of the statutory language helps you reach that conclusion?
Sure. It is, well, basically my argument is that these are ambiguous statutes, that you have two separate actions triggered when there's aggravated circumstances finding. One is that there's this statement that the agency shall not be required to make reasonable efforts. Another is that there is this that a permanency hearing has to be held within 30 days pursuant to 1623-23. When you read the language of 1623-23, there is no exception carved out for aggravated circumstances cases. It is not clear that at a permanency stage, the court cannot order a goal of reunification, even with aggravated circumstances findings. So I would argue that because of this ambiguity, the statute should be read in the light of the neglect statutes as a whole and have a holistic reading of these statutes. And if we took this interpretation that the government supports, it would mean that the court would never be able to order a permanency goal of reunification with a parent who has aggravated circumstances over the objection of the government, even if it believes it is in the child's best interest. And the sole discretion of whether it is in the child's best interest to have a permanency goal of reunification with a parent with aggravated circumstances rests only with the agency. And this interpretation is completely antithetical to the well-established principle that the court must act as parents portray and must act to protect the best interests of the children. And so this interpretation, one small segment of the neglect statute, would undercut the whole statutory regime in which neglect courts are obliged to act in the best interest of the respondents.
Can I ask one last question before you sit down? Judge Glickman asked what this fight was about, and I sort of have the same question. Is the claim for your client that you wanted reasonable efforts to continue, in which case it seems like the statute precludes the court from ordering the government to continue to make reasonable efforts towards reunification if the district is not interested in that, right? Or is your argument that the court should have had the leeway to maintain the goal of reunification separate and apart from reasonable efforts, even if the district didn't support that goal?
My argument is that the court should have an opportunity to hear the evidence and make the determination of what's permanency goal is in the best interest of the child, and understanding that in this context, most of the evidence might be presented might be about my client's progress towards ameliorating the conditions of neglect rather than reasonable efforts on behalf of the government.
Thank you.
Thank you.
Thank you.
We used up most of your time with our questions, but we'll still give you a couple minutes of your rebuttal time.
Good morning. May it please the court. My name is Sabine Brown and I represent Appellant DT. I would like to reserve 3 minutes of my time for rebuttal. DT seeks reversal of the lower court's order that affirmed the trial judge's decision to set a goal of adoption without an evidentiary hearing. The court should reverse the lower court's ruling because DT did not lose her right to an evidentiary hearing with heightened due process protections simply because the trial court made an aggravated circumstance finding. When the court contemplates setting a goal of adoption, the court should hold an evidentiary hearing, and the paramount consideration should be the best interest of the child.
Can I interject and ask a question? I think that we also asked counsel for T.J. Is your concern, your concern seems to be focused more on the goal change. Are you also concerned, were there reasonable efforts that were ceased that you're concerned should have been continued? And that is also a part of your concern with the goal change to adoption without a full evidentiary hearing?
Absolutely.
What were those, can I just ask for background, what those
Reasonable efforts
were?
the agency was ordered to make reasonable efforts for over a year in this case. And as a result of the aggravated circumstances finding, which the government requested on the day of the scheduled evidentiary hearing, reasonable efforts ceased.
What were the efforts that were ordered?
So
Ceased?
efforts, so one of the concerns was that there were no efforts made by the agency concerning domestic violence services for my client. But the case plan or the permanency plan for my client included things like mental health services, parenting courses, anger management classes.
Right. So I guess to get to our question of my colleagues to other counsel for appellant T.J., the fight is about the fact that your client didn't receive services that would have helped in the parenting and helped toward reunification. They were supposed to be provided for a year, and they were terminated after how long?
They were terminated after she was released from incarceration, and pretty much at the point where she was supposed to have the evidentiary hearing. And that would have been an opportunity for my client to demonstrate that the agency had not made reasonable efforts. One of the arguments that she had was that there were clear suggestions of domestic violence in this case, and reasonable efforts were not offered to her as it relates to domestic violence services. So that was a big concern for my client.
So could you help me out here? Suppose the hearing had been held and the judge says, well, for a year, they haven't been helping you while your client, with reasonable efforts, domestic violence services and the like. But I can't order them to do so because your client has pled guilty to second-degree cruelty to children. And her husband has pled guilty to first-degree cruelty to children. So I can't order them to provide those services to you. So tell me even if I, the judge, think it would be desirable to pursue reunification services. So what has been achieved?
So respectfully, Your Honor,
Excuse me?
Respectfully, I disagree that the court could not order reasonable efforts, require the agency to conduct reasonable efforts. I do agree.
Oh, well, if you're right about that. Sure, if the judge can override what the statute says, but let's assume we think, fair enough, let's assume we think that the statute means what it says, which is the district shall not be required to provide reasonable efforts to achieve reunification. Then what's the purpose of this hearing? Tell me what is achieved.
So the language.
My hands are tied, the judge says. I cannot, what am I supposed to do?
So, I mean, that is the crux of DT's position, is that the court's hands were not tied. For the court.
Okay, so you agree that if the statute I mean, this is what I want to find out. Do you agree that if the statute is understood to mean what it seems to say, which is that the court cannot require the district to provide reunification services in this situation, then, you know, that's the end of the matter. Whereas your argument is, well, despite what the statute seems to say, actually the court can require them. Is that what the fight is about? The sole fight?
Partially correct, Your Honor. If the statute were interpreted as Your Honor indicated, the problem with that is that it would eliminate the court's discretion in acting in the best interest of the child.
Well, it's a statutory determination that the district is not to be required to pursue certain efforts when the parents had done certain things to the child. The underlying premise is that when the parents have been so abusive, you know, we should be moving quickly to adoption.
So if I may, the language in DC Code 4-1301.09 AD should not be read so narrowly as to limit the trial court's broad authority to act in a child's best interest. The language at issue that the agency shall not be required to make reasonable efforts to preserve and reunify the family means that CFSA is not required to provide or to continue to provide reunification services until the expedited permanency hearing, during which the court would then get to evaluate and consider what is in the best interest of the child. So that interpretation ensures that the best interest.
If the statute actually said that, then I could understand your position, but the statute doesn't say anything like that.
But another way to interpret the statute would be to say that it could also be read that reasonable efforts are simply not mandatory, as opposed to interpreting it to mean that the trial court cannot set a goal of reunification. So in other words, while reunification is normally mandatory, in aggravated circumstances cases, the court can decide to set a goal other than reunification. And why this is important is because, as the court has said many times.
I want to draw a distinction that's probably worth, you know, no, I'm not suggesting that the parents should not be heard at or that the statute precludes the parents from being heard at a permanency goal hearing as to what's in the best interest of their children. They still have parental rights. Those parental rights have not been terminated. And any future termination of those rights will still require, you know, clear and convincing proof that they're unfit. But so there still need to be permanency goal hearings, and there still need to be considerations about what's in the child's best interest. But we're talking here about the specific type of a hearing called a TAL hearing, where the issue is really, should the goal be changed? Should the district's goal be changed? Now, the change in the goal, I'm trying to figure out what you think the change in the goal means if it doesn't mean that reunification services have to be provided.
It's my client's position, it's DT's position that the court can set reunification services, order the agency to provide reunification services at the expedited
Okay, so
permanency.
that's what the fight is about.
That's what the fight is about.
So at the permanency goal hearing, let me back up a little bit. What I understand your argument to be is that reunification, if it is a goal, requires that reasonable efforts and services be provided pursuant to those reasonable efforts.
Yes, Your Honor.
What support, I guess, in the statute would you find? Because without reunification services or reasonable efforts, then what is a reunification goal? I mean,
So
it seems hollow without the ability, in other words, if the court has the ability to set a goal of reunification, doing that without the authority to order reasonable efforts seems,
The reunification goal in and of itself is the court ordering the agency, the government, to provide the reasonable efforts services, the reunification services. And so DT's position is that
see, I understand that argument in principle. And so I guess I'm looking for how if you walk me through your understanding of the statute, how is there something that in this reasonable efforts provision that makes it clear that unification equals reasonable efforts and services?
So I think that the facts of this case can help. Just the fact that the court accepted the precipice filed by the children's attorney, the changed circumstances of my client, we can envision a situation where the court could determine that it would be in the best interest of these children to return back to DT's care. And if 4-1301.09A were interpreted the way that the government wants it to be interpreted, then the court would be limited, would not be able to act in the children's best interest.
I guess what I'm saying is I'm very sympathetic to this argument that you're
Okay.
making, but I'm trying to figure out how we support it statutorily. Because I think a big part of what we were looking at in NRA TAL was the fact that goal changes were made before there was an adequate hearing, evidentiary hearing for both sides, and particularly for the parents to show what efforts they had made to a successful reunification. But we were also, one of the concerns we were looking at was that services needed to be in place at a point in time that could meaningfully aid reunification if it was in fact the goal. And your argument, as well as counsel for the other appellant's argument, makes sense to me. I'm just trying to figure out how, with this language here, that the agency shall not be required to make these reasonable efforts.
I'm not certain that I fully understand the question, but I think that my response would be that the factors in NRA TAL are not just limited to reasonable efforts. I think it goes back to what Judge Easterly said earlier. There are other things that the court should be considering. The progress of the parents overall, what is in the best interest of the children.
Well, those could be considered in this circumstance at the reunification, in a goal change hearing or a TAL hearing.
Yes.
That there could still be an opportunity to hear what the parents have done without any services from the government. So what would be the problem with that scenario? I mean, suppose here the trial court agreed that we should still be working toward reunification. What have you done? The parents' response would be, well, we would have done this if we had domestic violence services, I guess is what you said.
Yes, I think that is
But then where would we be? They didn't do it. They didn't get the services. The district says they're not required to provide the services. So therefore, we can't move forward with the reunification. We have to do adoption.
But that's only if the statute is interpreted to mean that the court could not order the agency to make reasonable efforts. And our position is that the statute does not need to be interpreted so narrowly, because when you look at 4-1301.09A, it refers back to 16-2323. And so it clearly, in 16-2323, clearly identifies return to a parent as an option. Neglect Rule 34 also refers back, orders the court to issue, requires the court to issue an order. And the permanency plan, one of the options for the permanency plan is reunification with a parent. And so I think I think the main issue here is that the interpretation that the lower court took gave all of the discretion to the government, and that is problematic. Thank you.
All right, thank you.
Sorry, I'm out of time. I didn't realize.
Morning, Your Honors, and may it please the court. I'm Catherine Piggott-Tuke, appellee on behalf of the J children.
On
I'd like to
behalf
order-
of, I'm sorry. Who are you on behalf of?
On behalf of the J children.
Thank you.
I'd like to answer some of the questions posed this morning, but first frame two of the legal issues that the court's been focusing on this morning. First, are the children automatically deprived of the opportunity to have the court ever order a goal of reunification and the resultant reunification services that would require? And is the court automatically deprived of the authority to make that individualized determination if it's in a child's best interest? And two, are families with aggravated circumstances findings deprived of the due process protections of having the court hold a robust evidentiary hearing and make an individualized determination for each family before setting a goal of adoption? The answer to both questions is no. I'd like to turn first to the question that's been raised multiple times by this panel about whether the statute precludes the court from ever ordering the agency to make reunification efforts. And we contend the answer is no. And if I may, I'd like to kind of take a step back and walk through the two main relevant provisions here, the reasonable efforts statute 4-1301.09A and the permanency hearing statute 162323. So starting first with 162323, because I think that provides some context for how to read 4-1301.09A. That statute specifically sets out the options that a court can choose from when evaluating what's in a child's best interest for the permanency plan, and reunification is on that list. There is no prohibition there or specific carve out or exception for aggravated circumstances cases. And notably, farther up in the statute in section A3, there is a carve out for aggravated circumstances cases. Specifically,
Just to put a pin on that. So your argument is there is plain language that makes this clear.
that's correct, Your Honor.
Okay.
So we can see in 162323A3 where it specifically carves out aggravated circumstances cases. And again, and yes, to your question earlier, Your Honor, we use that for shorthand for these cases with these enumerated circumstances, because that's what ASFA, that's the language that ASFA uses. But there is a carve out there with respect to the timing of when a permanency hearing is held. But there is not a carve out later on with respect to the options the court can order. And so we can see that the legislature knew how to set out an exception and where it did and did not do that. So then turning back to 4-1301.09A, we believe there's some superficial clarity perhaps in the phrase shall not be required to make efforts. And that's essentially what ASFA set out to do is make a move away from reunification being a mandatory process, for reunification efforts being mandatory for all families. So what it says is that the agency, there's no longer a requirement, a mandatory requirement that the agency have a lengthy period of reunification efforts, but there's no prohibition there that the court order reunification. And the statute then goes on, if you look to section E of 4-1301.09A, it directs right back to 162323 and says that the court is to set a permanency plan, and then the efforts should be made to finalize that permanency plan. So again, these statutes were enacted together and intended to work in harmony, and reading them together, we believe that the text supports the idea that the agency, if a goal of reunification is made at the permanency hearing, that the agency then has to make efforts towards that goal. Now, we're not arguing
So
that.
I guess I don't, you've gone a little fast for me. I apologize. If the judge says, well, I think the goal should be reunification. So CFSA, I'm requiring you to provide reunification services. And the agency says, wait a minute, Judge, you can't require us. The statute specifically says we shall not be required to provide reunification services in this situation. What is the judge's answer?
We believe that the statute allows for a pause for a
The statute allows what?
for the courts and the agencies to pause any reunification efforts.
That
For
was
their-
my question, I guess, earlier. For this pause, you read as just a 30-day pause pending the time that aggravated circumstances are invoked by the district and the date of the permanency hearing 30 days later.
So in some cases, yes, it would be a 30-day pause. In some cases, the court would move swiftly towards a goal other than reunification, and it would be a much longer pause than that, Your Honor. So the point we're making is that ASFA set out to help courts move children more quickly to permanency, and making an automatic prohibition against courts setting reunification, which would then require the reasonable efforts, would take wholesale off the table one option for children to exit permanency more quickly. So we're not saying that the
See, I
court
take
should.
your point that as a matter of the due process rights of the children,
That's correct, Your Honor.
but nobody's really made that argument. It's alluded to in the dissents in TAL, I think, but it's not really been pursued. That argument I understand, that the children have a due process right to have a claim for reunification considered. All right, let's put that aside, since that's novel law and we don't really have that. The grounding for that here. Maybe we'll make new law in this case and then say that. But if we put that aside, then it seems to me Congress and the council were very clear. They were saying there are certain types of cases where we're not going to go through this process because the parents, we don't believe that we should be forced to reunify children with parents who abuse them in this way. Now, the CFSA has has discretion to say, well, in this particular case, we're persuaded to try it anyway. I understand the GAL in this case would like to see the children reunified with the mother. Okay, maybe you can persuade them of that, then, maybe at a future hearing you can get that. But it seems to me that the court can't order CFSA against its will to provide such reunification services. I mean, the Constitution doesn't provide, for even if the children have a due process right, I suppose, the Constitution doesn't, provide some right to reunification services from the government.
We would agree with that, Your Honor. Stepping back, first, we would ask the idea of children having due process rights not be taken off the table. We agree that
I'd be happy for it not to be taken off the table, but it's not argued before us in any, comprehensive way in this case.
I think that question is before us when we think about the TILE hearing. TILE set forth a due process right for parents and also for children to have a robust evidentiary hearing before the court sets a goal of adoption. So that would allow both the parents and the children to put forth evidence, to challenge the government's evidence.
That's what the termination of parental rights hearing is all about, really, and the adoption proceeding. I mean, that's when that's one place where the children's due process rights can be taken into consideration and the children get to be heard.
Yes, Your Honor.
Could get to be heard.
But turning back to your question of the agency having the sole authority, we think that prevents, that poses problems for a number of different reasons. First, it's an abdication of the court's authority here to make a determination in the children's best interest.
You mean, can I ask you, the agency having the sole authority to do what? To cease reunification efforts? Or
the idea that it's in the agency's sole discretion to determine I will or I will not make efforts for this family, that is an abdication of the court's authority. And that's what the court below ruled. We believe that could even pose a separation of powers issue here. It's the court that's the arbiter of children's best interests. And to give the agency the authority to be the sole determiner of what happens in a child's future, it takes away the checks that the system has built in to ensure that children's rights and best interests are protected.
Well,
So
but the agency, I'm sorry,
Sorry,
the
go
court
ahead.
could still order reunification.
that's correct,
here,
Your Honor.
And they just, one reading of this language is that they just couldn't go a step further and say, since I think reunification is an appropriate goal in the best interest of these children, now district, you still got to provide these services.
Under
Those
our
two-
reading,
Those are two different things. The first thing that court could do, and I don't think there's any dispute that the court could say, or maybe there is a dispute from the district that the court could say, we think reunification is still appropriate here, notwithstanding the aggravated circumstances finding. The question is whether the court could then go the next step and say, and therefore you must district provide reasonable effort services toward reunification.
we believe that those two inquiries go hand in hand, and we do not believe that the statute prohibits the court from setting a goal of reunification, and that would then trigger the agency to make reasonable efforts towards reunification.
But could we break it apart just for the sake of argument, right? Because I think the easier statutory question is whether or not reunification is, I understood the magistrate judge affirmed by the AJ to say reunification is off the table if there have been aggravating circumstances. And that seems clearly unsupported, in fact, contradicted by the plain language of the statute, right? If you look at 1623-23, it has no limitation, as you pointed out, on reunification as a permanency goal, right? Not for aggravated circumstances. And the council knows how to say that, and they didn't say that. So if we start there and say, no, a finding of aggravated circumstances does not preclude a determination of reunification, then we get to the thornier question of, well, reasonable efforts and how does this play in? And as Judge Glickman and the chief have said, kind of like, what is this fight about? And I see sort of two ways, and I'm sort of curious to hear your reaction to how one could think about this. One could say, okay, the district having taken the position that this parent has essentially committed a crime against a child and therefore is unfit, doesn't have to take an inherently contradictory position and provide reunification services to this person. But that's not to say that this person couldn't, of their own accord, seek out assistance, right, from their minister, right? Or, not the typical case, but if the parent happens to be of means, if this is a situation where there's some sort of addiction, right? The parent could go of their own accord and check themselves into the Betty Ford Center, right? They don't need the district to provide the services, but they still, at a TAL hearing, should have the opportunity to say, look, I've done these things, right? I have been counseled, weekly with my minister on, these issues. I have, graduated from the Betty Ford Center. And then there's this third piece of what is the court's reaction, right? I mean, we talked in TAL about having, the court's ability to grant or deny visitation, right? That's not about reasonable services, but certainly that impacts the ability, the goal of reunification, right? So putting reasonable services aside, one could still say that a TAL hearing has content and meaning and purpose before we even get to, well, do they or don't they have to provide reasonable reunification services to the parent pursuant to 4-1301-09A E if the court says. Is that a reasonable way of kind of picking this apart and taking steps? Because it seems like we need to kind of peel away the things that are easier before we get to the thing that is harder, and I think the hardest thing to deal with here is what do you do if the district, doesn't have to under D provide reasonable reunification services, like for how long and under what circumstances?
So absolutely to a lot of what your honor said, I would answer that, I think, by saying yes. And absolutely, there is more to a TIL hearing than just reasonable efforts, an opportunity for the parents to put in evidence about progress that they made on their own. This court ruled that if the prongs are met, that an adoption goal would be presumptively in the best interest of the child. And so as the GAL, the GAL will put on evidence as to what is in the child's best interest, evidence as to the parent-child relationship, as to the sibling relationship, about what the child's future might look like under an adoption goal, as opposed to a reunification or another goal. So absolutely, the TIL hearing is a meatier requirement with constitutional underpinnings than just the discrete piece of reading.
Could I ask you a question? Is there a distinction between a TAL hearing, which I thought was for a very narrow purpose, to satisfy the Constitution, and the other types of hearing? The district makes this point in its brief: a permanency hearing and a disposition review hearing. Nobody's saying, I didn't think, nobody's saying that the parents are not entitled to disposition review hearings and permanency goal hearings, at which the parents, are entitled to present the court with information. And they certainly should be heard. For example, they should be heard about whether the current status of the children is in their best interest or not. There's lots of questions that could come up. But I thought the dispute here was not over those kinds of hearings, but over specifically whether the parents are entitled to a TAL hearing, at which I thought the central issue was what's the goal, and if the goal is reunification of the children with the parents, whether the CFSA is doing what they should be doing to provide reunification services. So nobody's saying that the parents can't be heard. They should be heard, in fact, on all sorts of other issues. But that's not a TAL hearing. That's not a constitutionally required, what TAL was talking about, I didn't think.
So two responses to that, Your Honor. Under the court's interpretation and the government's interpretation, there is no hearing. There is an automatic setting of a goal of adoption for children, and it takes away the court's ability to even consider any of the evidence that we've talked about today about.
Well, there has to be a hearing to determine, for example, first of all, there are other options besides adoption.
Sure.
Or besides adoption and reunification. So that's one thing. Second, there's the question of whether the children are being adequately cared for now. And third, whether they're moving properly and expeditiously toward adoption. I mean, there are all sorts of reasons why the court should hold a regular hearing. Now, this can be done, but it's not the same thing, I didn't think, as what we meant when we talked about a TAL hearing.
That's correct, Your Honor, that it's not the same thing. So we would certainly be pushing for some hearing, but TIL is requiring more than.
Often it can be done on the papers, but.
I'm confused. Nobody is saying that there shouldn't be a hearing. I mean, that was the magistrate judge's ruling, right? No hearing.
That's correct.
Aggravated circumstances. Goal is going to be adoption. We're done, right? So
absolutely, Your Honor.
So that's what this is about.
That's what this is about.
Okay. And then as far as what a TAL hearing is, I mean, I guess I'm curious, do you agree that the parents' efforts, separate and apart from the reasonable efforts of the government, are not part of a TAL hearing? Because I am looking at TAL and it seems to be in the conjunctive of we're looking at the parents' efforts and we're looking at the district's efforts. So that seems to be pretty express in TAL, but do you disagree?
We believe that the parents' efforts is a critical piece of the TIL determination. In addition to what's in the children's best interest, the court deliberately set forth 4 prongs and deliberately made a statement about whether that is an equivalency to children's best interest, and to subsume that test under just reasonable efforts would completely gut the child due process protections that were provided in that case. And there's certainly no reason to believe that children with aggravated circumstances findings are not entitled to those same due process protections as all other children in the district.
Can I take you back a little bit to a statement you made about, in response to my question about the judge having discretion at a hearing to determine a goal change, even under a situation like we have here with aggravated circumstances, where the judge could say, despite the aggravated circumstances finding, after hearing testimony from all parties concerned, I still think reunification is appropriate. Then that gets us to this language in that we've been toiling over here, 4-1301-09A, that said 09AD, that says the agency shall not be required to make reasonable efforts to preserve and reunite the family. How do you read that? If I look further in the statutory provision under D1, I guess it would be E. 09E. If reasonable efforts were not made pursuant to subsection D of this section. And then we have 1 and 2. 1, a permanency hearing conducted pursuant to 1620-323 shall be held within 30 days after the determination that reasonable efforts are not required. And then, and 2, reasonable efforts shall be made to place the child in a timely manner in accordance with the permanency plan and to complete whatever steps are necessary to finalize the permanent placement of the child. How do you, I mean, to me, that sounds like there's room there to require reasonable efforts if the goal is still going to be reunification.
Absolutely.
Or are these to be read? It says and 1 and 2. Reasonable efforts shall be made to place the child. When you talk about placement of a child, does that mean we're automatically outside the realm of reunification?
No, Your Honor, that's not how we read that. Again, we would look back to the options enumerated in 2323. One of the options is return to a parent. And we believe that E1 and 2 read together and again, read in the entire context of the reasonable effort statute and the permanency hearing statute, that it permits, if the permanency plan selected at that permanency hearing as a reunification, the reasonable effort statute then directs the agency to make efforts towards that plan. Again, what aggravated circumstances results in is a pause and then a fast forward to the permanency hearing. And so in those cases, the court could move swiftly to a goal other than reunification. We're not saying that the court should set a goal of reunification in all or even most aggravated circumstances cases, just that the text does not prohibit the court from doing so, and that would then trigger the agency to make reasonable efforts.
Okay, can I ask one more question that is interesting to me? And as the GAL, you changed your view on the goals here. At one point in these proceedings, you favored adoption. Well, first it was reunification, then there was a period of time, if I'm not mistaken, where you thought adoption was appropriate, and then changed it back more recently to reunification. May I ask why?
That's correct, Your Honor. So the role of a GAL is to consistently and constantly evaluate the facts as they evolve on the ground. Thinking about the role of the GAL supports why there should be no sort of automatic determinations in family law, like the court below and the government are seeking here. And so in her role, the GAL, as the facts evolved, there's a parent here who has made a considerable amount of progress. Children who have been removed from their pre-adoptive home based on abuse at the hand of the foster parent, separated from one another. And this is the exact case. Looking over the facts as they stand today, the GAL believes that the mother could reunify with the children imminently, and that there's no reason to believe that these children would exit foster care more quickly to a goal other than reunification than to reunification.
Are the children still in two each in two separate foster placements?
That's correct, Your Honor.
And neither of the foster parents at this point has petitioned for adoption?
That's correct, Your Honor. I know my time is out. I had a few more points I was hoping to make about the purpose of the statute and the legislative history, if I may. As we've discussed today, we do not believe that the text of the statute prohibits the court from setting a reunification goal, which would then trigger efforts. But this court can also look to the purpose of the statute, which is moving children more quickly towards permanency, a move towards elevating children's rights over what was believed to be elevating parents' rights over children because of a push to reunification, and to deprive the court of the authority to make a determination about what is in children's best interest would thwart the purpose of the statute of ASFA to move children more quickly towards permanency and to elevate children's rights. ASFA didn't push for adoption's sake. ASFA seeks to move children out of foster care, to not have so many children lingering in foster care, and our reading of the statute serves that purpose.
Well, ASFA does not prevent CSFA from providing reunification services in an aggravated case. It's up to CSFA. What ASFA seems to do, in effect, is to say that decision is to be made by CFSA, not by the court. And, you know, that's a legitimate legislative choice, it seems to me. And I find it very I find it very difficult personally to read these statutes and see how the court can override a decision by CFSA not to provide reunification services. I may not like that. I may agree with you wholeheartedly that the children, that sort of regime is not in the children's best interest, but the statute is pretty clear, it seems to me. And when you talk about all the statute provides is a pause, to me, that's a funny way of looking at it, because what the statute really provides is acceleration. Normally, the permanency hearing will say be 6 months or a year down the road. Whereas the statute says, look, in these cases where there's been this kind of aggravated behavior by the parents, in 30 days, you hold a permanency hearing. Let's get this thing moving. That's not a pause. What they have in mind is these children are not going back to the parents in all likelihood. And we want to get this we don't want there to be any delay in moving towards an alternative permanent placement. So, you know, it's a policy choice that they've made, and they've made it to me pretty clearly in, you know, on uncompromising language in the statute. 2323 is a general statute that provides for permanent hearings, and all these things are considered. But the section the section in Title IV is much more specific when it says that, you know, CFSA shall not be required to provide reunification services in this particular situation. So I guess what I want to ask you is, if you agree with me, if you were to agree with me, that the court here, whatever its view of reunification is, cannot order CFSA to provide reunification services for these children if CFSA does not want to do so, then what is the practical effect? What are the consequences of the court saying, well, I'm not changing the goal. I'm keeping the goal as reunification?
So we think there would be drastic consequences of this court reading the statute to say that the court is deprived of its authority to ever set a reunification goal that would then trigger reasonable efforts for children. We do not.
I understand that's the concern. I understand that, but I'm looking at a statute that, as I said, looks pretty uncompromising. So if the uncompromising reading is correct, tell me what is achieved, what the consequences would be of the court saying, well, I think the goal should remain reunification, because it doesn't stop anybody from doing anything under those circumstances. It doesn't stop CFSA from immediately proceeding to push for adoption. It doesn't stop a termination of parental rights. I mean, you see what I'm saying?
Yes, we do think that the court setting a reunification goal without all the protections and the requirements that it includes would be taking a significant amount of power away from the courts to direct where a case would go. And we do not believe that ASFA made that policy choice, or that DC in enacting ASFA made that policy choice. DC could have gone further and specifically said at that permanency hearing, the court cannot set a goal of reunification. That's off the table, and it didn't. It made a carve out for aggravated circumstances and other places of the statute for the timing of the permanency hearing, but it simply did not make that policy choice when it enacted ASFA. And looking to the legislative history of ASFA, it's not clear that that was the policy choice that ASFA was making either. ASFA was a move away from mandatory reunification. ASFA amended Title IV of the Social Security Act, which said to get funding for state foster care agencies, agencies have to make efforts to reunify. And ASFA said, no, we're going to take a step back from that. It's no longer mandatory. States can no longer say it is mandatory for there to be a period of reunification efforts, but it does not say that it's prohibited. In the government's brief on page 25, it cites a quote from the legislative history that says that states must abandon reasonable efforts. Reading that entire paragraph from the congressional report, it actually says that states are allowed to bypass reasonable efforts. And then that statement was presented, it's being read in isolation. There are numerous statements in the legislative history that support the idea that this is a permissive move away from reunification, not mandatory. So if I may just give a few seconds.
Everybody agrees. I mean, CFSA would agree that they're not mandatorily required to stop reunification efforts. But if they decide to, the statute says they can't be required to. That's a different proposition.
But what I'm speaking to is that the purpose of the statute, the legislative history, we believe even a reading of the text supports that that's not what the statute says. It says that reunification efforts shall not be required anymore. Not that the court is prohibited from ever following the steps of the statute, ordering reunification, which would then trigger the reasonable efforts.
Well,
So-
even in non-aggravating circumstance cases, a decision can be made. I mean, reunification efforts are not required by law are they under any technically under any circumstances. They may be presumptively, this is where we're going, we're going to try, but reunification, I mean, there are many cases that are not aggravating circumstance cases where, we're stopping reunification efforts because for whatever reasons we have, and they're allowed to do that, right?
Sure, the court can set an alternate permanency plan, and then the efforts would be directed towards whatever that plan is. So that's correct.
So,
Right.
so to say that, I mean, it seems that to say that, well, the statute simply means that reunification efforts are not mandatory. Isn't quite the right interpretation in the aggravated circumstances situation. Doesn't quite get at what they're doing, because to say that is to say, well, they're not mandatory in other circumstances either. Everybody agrees on that.
The fast forward, the acceleration is a significant thing to look at here. So yes, it's true that the court could move more swiftly in other cases, but in practice and looking at the reasonable effort statute, the focus in most cases is to begin with reunification for a period of time, typically 12 months. It's true that courts aren't constrained from bumping that timeline up faster, but typically courts follow the idea that reunification is the presumptive goal where we start. And this acceleration is a big deal for children and for families. It asks the court to make a determination of a permanency plan and allows them, under the reasonable effort statute, to move quickly away from reunification if that's what's in the best interest of a child.
Okay.
So we're not saying that that's prevented. We're saying, I mean, aggravated circumstances covers a wide range of cases. Yes, it catches kids where there has been horrific abuse, and courts can move quickly away from reunification in those cases. But it also catches, for example, involuntary termination cases where maybe a parent's rights were terminated with respect to one child more than a decade ago. And here we have another child that comes in, and maybe this child comes in for something like educational neglect. And under the court's reading and the government's reading, they're saying that that child, that sibling, 10 years later, the court can't even consider the circumstances of the prior involuntary termination, why this case came in, the current parent's ability to parent the current child. And so aggravated circumstances, it casts a wide net, and to read the statute in a way that leads to an automatic determination that reunification is off the table. Simply, it's not required by the text. It's not required by the purpose. It's not required by the legislative history. And we believe that that would have significant constitutional concerns.
Okay, I'm gonna stop you there just because we've been extremely generous with the time here, and I know we've had many questions for you. We'll hear from counsel for the district at this time.
Good morning, may it please the court, Pamela Sanchini on behalf of the district. The statutory provisions at issue here are not dealing with the typical case. They're not dealing with the ordinary case that CFSA sees. They're dealing with narrow and extreme situations like this one, where a parent's conduct results in egregious harm to a child. Here, the parent's conduct resulted in harm to.
But I thought that's just what the GL was saying, is that if we're looking at aggravated circumstances, that casts a wide net. So, I mean, my concern really is that, you know, bad facts make bad law, right? And we have, you know, some chilling facts before us here, but we're interpreting a statute and we're trying to decide if the magistrate judge could just say, no hearing, right? We are just immediately going to a permanency goal change of adoption. So how do we get there? Is the district defending that decision? No
Yes.
hearing?
Yes.
Okay.
What the magistrate judge said was there was no TAL hearing. There was no hearing to determine whether family reunification efforts should continue.
Okay, can the district explain to me what it means by a TAL hearing? Is a TAL hearing a hearing to determine whether the permanency goal should be changed?
Yes, but it's a hearing to determine if the goal should be changed because the government has met its obligation to provide reunification efforts and whether
Solely?
those efforts should continue.
So solely? Isn't that one area of inquiry, but it's not the only area of inquiry?
It's the only purpose of the inquiry. And yes, there are other factors.
I'm reading from TAL, right? And I read from this earlier. So we said it makes sense that the primary focus of the permanency planning hearing, and we're talking about the TAL hearing, right, should be on the parents' efforts to ameliorate the conditions that led to the neglect and the district's efforts to assist them in achieving those goals. Right?
For the purpose of determining if the agency met its obligation and whether those efforts should continue.
No. It says we're looking at what the parents did
Yes.
and what the district did. So if the district did nothing, it would still be relevant to know what happened with the parents, right? My hypothetical of, you know, the mother goes and meets with her pastor on a weekly basis for hours to work through the issues that led to the neglect, right? That gets to be considered at a TAL hearing to decide whether or not it's appropriate to change the permanency goal. No?
Absolutely. That gets to be considered
Right.
to
But
determine what.
But the magistrate judge would have said, there are aggravating circumstances here. I don't need to have a hearing about how this mother has been working on her own to ameliorate the circumstances that led to the neglect in this case. Is that correct?
It's correct that she determined that a TAL hearing was not necessary because
Can we just stay like a magistrate judge would stay concrete, would have said, I don't need to have a hearing to hear about the mother's personal efforts to ameliorate the conditions of neglect. Is that correct?
Yes, among other things, but the purpose of TAL is to determine whether reunification efforts should continue.
I thought
taking into
the
account-
purpose, we're going around in circles. I thought the purpose of the TAL hearing was to determine what efforts the district had made and whether those efforts were sufficient, but also what the parents had done. Do you
Correct.
disagree?
I don't disagree,
Okay.
because if a parent has made progress, sufficient, adequate progress that TAL describes, then the reunification efforts should continue.
Okay, and one more time, the magistrate judge in this case, by virtue of determining that there were aggravating circumstances here, would say, I don't need to hear about the efforts that the parent has made.
She did not need to hear in the context of determining whether the goal should be
Or
changed or efforts
Not,
continue.
I don't need to hear, but you, mother, are not entitled to a hearing to put on that evidence before me because there are aggravating circumstances in this case.
I don't think she said you don't get a hearing about anything ever. I think what she said is we're not having a TAL hearing to determine based on these 4 factors whether we should continue.
I thought the magistrate judge said, because there are aggravating circumstances here, the only goal can be reunification. So there's no point in having a permanency goal hearing, a permanency goal change hearing, because we have to go to reunification. Did I misread what the magistrate judge said?
You did not misread what the court
Okay,
said.
so if that's true, and the magistrate judge is saying the only goal is reunification, then I don't understand how a mother, like I'm hypothesizing, could say, but wait, I would like to put on evidence about the changes that I have made to ameliorate the conditions that led to the neglect of my child. The magistrate judge would say, again, there are aggravating circumstances. The only goal is reunification, and your evidence is irrelevant.
Well, I would say 2 things. One, a parent is entitled to, I would say a parent is entitled to an evidentiary hearing on whether aggravated circumstances in fact exist. One was not requested.
Nobody's fighting here in it, or in my hypothetical, that there were aggravating circumstances.
At every permanency hearing, the court is required to determine whether the child can be returned home. And I'm not saying that that can't continue to happen while the goal is adoption. So
No, but the question is what the goal should be, right?
correct.
Because we said in TAL, there are lots of things that happen with the change in the goal, right? Among them, whether or not the parent can visit with the child, right? So,
Well, I would disagree on the visitation part, because visitation continues in every case unless it's terminated by an evidentiary trial or termination of parental rights. As the court saw in the GAL's precipice, the mother has continued, in fact, to visit. The father has not, because he continues to be incarcerated.
right, but if the goal did change and you said, look, the goal is going to be adoption, then I think how one would order visitation would change, right? Because
Except that
the
it doesn't.
visitation, well, maybe in practice right now, but it certainly could, right? A judge could say, it is time for these children to move on and to see less of this person who is no longer going to be their parent, right? And so we don't need to have weekly, hours-long visits, right? That's not necessary because the goal is adoption, right? And that will just cause pain to these children.
I
and
assume your
confusion.
position would be that if a judge tried to terminate a parent's visitation rights, then the parents would be entitled to a hearing on that because their
course.
rights have not been terminated. What I hear you're arguing is that the purpose of the TAL hearing is, as opposed to just permanency hearings in general, the purpose of the TAL hearing is to determine whether the district, or the CFSA, has been meeting its obligations to provide reunification services, and if not, then to order them to do so. And that everything that is, while it's certainly true that all sorts of information can be provided to the judge at that hearing, including the parents' own efforts, the issue, your position is simply, is the district meeting its obligation or not? And if the district has no such obligation, your argument is, because of the statute and the implementation of ASFA, then what's the point of the TAL hearing? There is no point.
Correct.
Now, that doesn't, I take it though, your position is that permanency goal hearings, or at least I had not understood your position to be that permanency goal hearings should be terminated. And if the magistrate judge meant to say that, then I would think that's a different issue. And I think that the magistrate judge might well be wrong if she meant to say that. Do I have your position, before we get to my own questions about this, do we have your position correct?
Yes, that is my position, that the permanency goal hearings continue.
Okay, now suppose we have a permanency goal hearing. And I take it that at a permanency goal hearing, the parents can present whatever evidence they think is relevant on that question,
Yes,
which would include things like, how's my child being taken care of now? And is this current situation okay? It really blends with a disposition review hearing. If the judge is persuaded to say, look, notwithstanding the aggravating circumstances that originated this proceeding, you've made such progress, D.J., that I am persuaded that the goal should either remain or should be reunification. Okay, let's suppose the judge says that. And CFSA says, okay, well, you could say what you want, that's fine, but we're not going to continue to provide reunification services because, we can't be required to do so, and we don't agree that they should be provided. What is the consequence of if we're at that point in time, at that stage, what in your view is the consequence of the goal change to reunification?
the district's position is that the goal can't change to
The goal cannot change.
reunification.
Your position is the
That-
goal cannot change. to
How
reunification.
can that be?
Well, let me just hear what your
Under the-
position is.
under the
Yes,
statute.
my position is that at every permanency hearing, the court must consider whether the child can be returned home. And if the child can be returned home, certainly the court can do that. If a parent has made sufficient progress to warrant return of the child to the home, the court can do that. What the court can't do is set a goal,
Well,
wait
suppose-
and see if that
Wait,
happens.
I want to pursue this for a moment. Suppose the court says, well, you're making a lot of progress, TJ. You're not there yet. I can't return the children to you. I can't just end this proceeding now and return the children to you. But I really see a lot of hope for this. And I noticed the GAL is equally optimistic about that. You're saying despite all those things, the judge cannot change the goal to reunification?
Correct. I'm saying that the court could send the child home, but not set a goal of reunification to
It's
see.
a little odd, isn't it? I mean,
What's the
sending the
difference
child
between
home.
sending the child home and reunification?
Because the goal of reunification is to make efforts to see if that eventually happens. But to do,
So that's consistent with what the GAL said, that if you're talking about reunification, that automatically seems to imply that there are efforts presumably on the part of the district to aid in that reunification.
of course, if the goal is reunification, the agency will make efforts.
So let me ask how you interpret the two provisions of the statute that I asked the GAL about. If we're looking at 4-130109A D, where it says the agency shall not be required to make reasonable efforts to preserve and reunite the family. And then you jump down to E, and it says if reasonable efforts are not made pursuant to subsection D, and then I'm going to go to E2. Reasonable efforts shall be made to place the child in a timely manner in accordance with the permanency plan and to complete whatever steps are necessary to finalize the permanent placement. So as I read this, I'm thinking when you get to that hearing 30 days from the date that the aggravated circumstance provision was invoked, you then do have an opportunity to revisit essentially whether reasonable efforts and what they might be are to implement the permanency plan. I don't see where that language reads out the opportunity for that permanency plan to still be reunification if the judge thinks that's appropriate, or guardianship or adoption. But it seems to me it's that at that 30-day hearing, 30 days after the aggravated circumstances, that you are essentially on a fast track, as the GAL says, revisiting the whole issue of what's the appropriate goal for these children in light of these aggravated circumstances. I guess my question is to read it as the district suggests seems to read out section E1 altogether from the statute.
I don't think it reads out section E. It does. So after the child is committed, we have a series of review hearings.
I understand
before we get to
reviews.
permanency.
I'm talking about where the language of the statute says within 30 days after the aggravated circumstances provision is invoked by the district, you have to move quickly, 30 days as opposed to the usual time within which you'd have that hearing, to then determine what the goal for these children should be and what reasonable efforts we need to make to get them there. I don't see where this says that permanency goal cannot be.
So what the district is relying
reunification.
on is the language of 162323, that in a typical case that's not aggravated circumstances, or more quickly in an aggravated circumstances situation, once you get to the permanency stage of the proceedings, the court should consider whether the child can return home or placed for adoption or guardianship. We're no longer at a point where we're trying.
That's what I'm trying to pinpoint, where you say you no longer have to even consider at this new 30-day hearing, if we would have had it in this case.
So I am looking at the language
Reunification.
of 162323, the same language that opposing counsel here rely on to say that reunification is a goal. The district relies on to say, but not yet at a permanency hearing. At that point, you're
But where
considering
is that language?
162323C. The purpose of the permanency hearing shall include a determination there, whether the child can be returned home or placed for adoption or guardianship or another planned permanency option. We're no longer at a point in a proceeding where we're trying to make efforts towards reunification, because we've either been excused from those efforts or we've exhausted those efforts. And so we're now at a point where we're.
But E2 says reasonable efforts shall be made to place the child in a timely manner. So you're not beyond reasonable efforts. And so I'm trying to figure out what the reasonable efforts mean in section E2 here.
But we are beyond efforts towards reunification. We're making efforts towards another permanency plan if the child can't be returned home.
I guess I keep missing where reunification is written out.
Well, it's not written out in 162323 where we're talking about permanency hearings. At that point, at this juncture, we're talking about either return home or another permanent plan.
Well, isn't reunification a permanent plan?
It is a permanent plan, but
So
what
why
the
is it written
statute
out?
says is returned home or placed for adoption.
Isn't return home reunification though? I guess
It is reunification, but we've achieved reunification at the time we get to return home. We're not setting a goal of a potential reunification at some unknown time down the road. So what the statute is intended to do is get more quickly to a permanency where the child can either go home.
So couldn't at this hearing 30 days from the aggravated circumstances determination, couldn't there be a situation where the trial judge says, I think these children, to use your words, should be returned home within 60 days. And during that time, I want the district to step up the counseling on mental health and on domestic violence so that in 60 days, these children can be returned home. Why is that precluded, as I understand the district to be arguing?
I think it's precluded by the language of Title IV that says we shall not be required to provide. But if I could
That's in
just.
D, but now we're down to E, where it
Correct.
says reasonable efforts shall be made. Reasonable efforts shall be made. And that's what it says. So it seems to kind of undo or qualify what is said in D about reasonable efforts shall not be made. or need not be?
I think if it's read that way, it absolutely would undo the provisions that give the agency. And if I could just back up a tiny bit,
Mhm.
if a parent is making progress, if a court is in a position to find that in 60 days the child can be returned home, that's not a situation where the agency is going to elect not to provide services. The agency wants to return children home when it can. The agency continued to help the mother in the situation. Excuse me, they referred her to a parenting class. They referred her to House of Ruth when they discovered while she was incarcerated for the first time that there were domestic violence issues. They continued to facilitate visitation. They referred her for a substance use assessment. It's not a case where the agency wants to do nothing because it has the option to do nothing. If a parent is close.
And that actually,
Mhm.
I'm not quite sure why that helps your argument, right? I mean, here we are, and we've got a court order that I thought you were defending, but now you've said, no, there should be a hearing. But the court said there should be no hearing because there's no other goal other than reunification. So what's the point in having a hearing, right? So, and if we have a hearing, as the chief has said, you have the hearing and the court gets to say, this is what I think should happen. I think we should continue to pursue reasonable efforts. Now, I tend to agree with the chief's understanding of E2, but even if you disagree with it, once a court has said, I really think reunification is the way to go here, it does seem hard to envision a circumstance where the district would be like, well, we don't want to, and we're not gonna, right? I mean, it seems like it would carry some weight that the court is saying, I see a path to reunification here. And as you say, that the district would then continue to provide these services, either pursuant to court order of their own volition. But none of this is what this case is really about. This case is really about the trial judge saying, the magistrate judge saying, you just don't get a hearing. It's automatic adoption, goal change, no reunification. So I sort of feel like we're sort of far afield from what brought us here to this appeal.
I don't think we're far afield. I think what the magistrate judge said was you don't get a TAL hearing. That is not to say that you don't get a hearing on some other issue if there's some material factual dispute that the parents want to present to the court. But that wasn't the case here.
I mean, I'm looking at page 12 and the court says, once the court made aggravated circumstances findings, the parties could have sought any permanency goal other than reunification. But according to the express language of 4-1301-09A, D1A, the court was precluded from ordering reunification. And then it goes on and says, you just don't get a hearing.
You don't get a hearing on that issue.
But that's the issue that the parents want a hearing on. They don't want the permanency goal changed. They would like reunification to continue to be the goal, right?
That's correct, Your Honor. But they don't get a hearing to establish whether reunification should be the goal because the agency has now been excused for making reasonable efforts, and a goal of reunification would require the agency, contrary to the provision in Title 4, to make reasonable efforts. But a parent certainly would be entitled to a hearing on whether the child should return home, a hearing on protective supervision, a hearing on whether aggravated circumstances exist. They just weren't entitled to this hearing. Because the purpose, the end result of a parent having proving that the agency failed to make reasonable efforts for the previous 15 months would be to continue reunification efforts. And that option is now off the table.
Do you think that the judge's opinion can be read as narrowly as you're reading it now?
Yes.
Or do you think that at a minimum, it would be good for the judge for this court to clarify the limits of the ruling?
I don't think it requires clarification. I think the parties presented for a TAL hearing. She recessed the TAL hearing to allow the parties a chance for briefing, and then found that because aggravated circumstances existed, that particular type of hearing was no longer necessary. And she set the goal of adoption.
So if the parents came in If, for example, the GAL and T.J. came in and said, well, we think the children should be returned home now.
Then the
They'd be-
district's position
They'd
would
be
have been
entitled to a
different.
hearing on that.
I would say yes.
I assume it would be an evidentiary hearing.
Yes. If there was some, again, a material factual dispute as to what the parents are going to prove and what the district, then yes, an evidentiary
I
hearing.
disagree. So,
Yes. Then I would say, yes, they would be entitled, but that wasn't the situation here. The parents were not asking for the child to be returned home. They were asking for continuation of family reunification efforts, which was precluded by the finding of aggravated circumstances.
which particular efforts did the CSFA seek to discontinue?
CFSA wasn't seeking to stop the services that were in place. They were seeking an order terminating the requirement, the obligation to continue, to shift their efforts to finding a permanent plan for the kids, to shift their focus.
Fair enough.
Towards
I
adoption.
didn't state that, but maybe I should say which reunification efforts were the parents or TJ or the GAL seeking to have the court require be continued?
Well, I don't know which efforts TJ was seeking to continue because he remained and remains today incarcerated, but
Oh, right.
certainly,
She's not released yet, right?
so DT on the other
I
hand,
assume visitation is one of them, but
DT was permitted to have continued visitation. She was provided the services that I listed earlier. She was referred for a parenting class and referred for domestic violence counseling. She had the assistance and support of a lot of people.
does the record indicate whether those services are continuing or not?
I think there's reference to some of those services in the precipice filed by the GAL, but all of those happened post judgment here. So those are things that have continued since this case came on appeal.
Mhm.
So they're not in the record other than what is referenced
Right.
in the supplement.
Okay. Anything
would also-
further? I know we've peppered you with questions. We are way over time, and I thank parties in the other cases for your patience.
Thank you, Your
Are there any
Honors.
final?
The district would ask the court to affirm. Thank you.
All right, thank you. Counsel for TJ, sorry, Counsel. Ms. Bauer. Give you 2 minutes.
I'll be very brief, Your Honors. I just wanted to address the honors question that if the court agrees that the trial court has discretion to grant a permanency goal of reunification, even with an aggravated circumstances finding, does it also have authority to order the agency to make reasonable efforts? And I would indicate that they do. Obviously, if the trial court makes a determination that the permanency goal of reunification is in the children's best interest, they are acting as their roles of parents betray. And to cite JJC, under our statutory regime, the court in a neglect proceeding acts as parents betray. In that role, the court has a paramount obligation and broad authority to protect the best interest of the child. And if you look at 4-130109AA, this language is somewhat mirrored in the statute itself. In determining and making reasonable efforts under this section, the child's safety and health shall be the paramount concern. So my argument would be if the trial court in its role as parents betray determined that a permanency goal of reunification was in the children's best interest, it would trigger 4-130109AA. And that language, the plain meaning of that would trump the language of 4-130109AD, because the health and safety of the children is the paramount concern when determining and making reasonable efforts under that section.
Thank you.
Thank you.
Ms. Brown?
Thank you, Your Honor. I do not have any further rebuttal. I would just ask that the court reverse the lower court's ruling setting the goal of adoption and require that the trial court hold an evidentiary hearing if adoption continues to be contemplated. Thank you.
Thank you. All right, I'd like to thank council and parties for your arguments today, and we'll take this matter under advisement. All right, our second case today is the consolidated appeals of David E. Washington versus Eugene Allen Jr. et al. I'm sorry, counsel, I couldn't hear what you said. Oh, no problem. You're waiting for co-counsel. Okay. Counsel, will you be doing any part of the argument on behalf of? You will not? Okay. And I guess counsel for appellees, do you plan to divide the time for argument? And if so, could you just let the court know what your plan is?
Yes, ma'am.
I can't hear you.
This will be divided time.
Okay, thank you. Counsel, are you ready to proceed?
Maybe 15 seconds.
Sure.
Good morning, your honors. May it please the court. This is Rachel Jennings on behalf of David E. Washington, the personal representative of the estate of Rita L. Yates. And I'd like to reserve 3 minutes for rebuttal.
All right, thank you.
To begin, I have one very quick jurisdictional point. There's been a timely notice of appeal that has been filed both in response to the motion to dismiss the complaint for adverse possession and the order of sale that was predicated upon that complaint or upon that dismissal. So all the issues are before you properly today, regardless of what you decide about the motion for reconsideration and its appeal. So if you don't have questions about that, I will move along to the substance of this case. Your honors, Rita E. Yates has owned this property outright since 1997. Nobody made any claim of ownership, had any questions of ownership or possession until 2008. And even then, there was no claim that was right before any court until 2014, when the estate of Lydia Yates was reopened. That is the decision, and that is the case that brought us to the 2016 order that's in question today. And your honors are being asked to decide whether or not that 2016 order precludes Rita Yates from raising her adverse possession claim now? And Your Honors, it does not, for three reasons. First, Rita E. Yates already fully perfected title in the property before that 2016 order was issued. Second, Your Honors, that 2016 order did not fully determine the ownership rights in the property. And third, even if that order purported to determine the ownership rights, res judicata does not bar the adverse possession claim because the facts underlying both of those claims are entirely distinct. So I'll move to the first point. Your Honors, Rita E. Yates' ownership interest had vested entirely prior to the 2016 order. It had vested back in 1997. That is the period for adverse possession.
Can we start in a different place?
Sure.
I mean, let's assume for the sake of argument that she had a winning claim of adverse possession. Why shouldn't she have raised it in 2016?
I don't think the question, Your Honor, respectfully, is whether she should have raised it, is whether or not she was required
Well,
to raise it.
clearly she didn't, right?
That's correct.
And the court is adjudicating who owns the property, right? And she never says, wait, never mind about these estates and, whether, how this goes through probate, or I own this property by adverse possession. Didn't she have an obligation to do that?
Your Honor, respectfully, I don't believe that she had an obligation to do so in that proceeding for two reasons.
Why not? I mean, let's just think really practically, right? What is res judicata about? And without getting into all sorts of complex, doctrine or use of Latin terms, it's about not wasting everybody's time. And so if she thinks that she owns the property outright at that juncture, that seems to be the time when she should be telling everybody, this property is mine, I don't understand.
Sure. And respectfully, Your Honor, she had already raised herself out into the public as owning this property. And not just by her actions, but I mean by filing
Perhaps out
the
in the
deed.
public, I'm talking about before the court.
And what I mean, Your Honor, is that in 2014, in February of 2014, she filed a deed with the District of Columbia stating that she owned the property as 100%
Right,
interest.
so put that deed before the court in 2016.
Your Honor, I believe it was before the court. And she did not raise it in I think, part of the issue here is like the access to the record. But I don't believe that she raised it certainly as I own 100% interest. But what was being decided in 2016 in that order wasn't full ownership rights, at least as she understood it. What was being decided was that Frank Yates Jr. had raised a claim saying that he was entitled to rights of survivorship based on the 1955 deed that had been given to both either Frank Yates Jr.
And that's when she says, forget your rights of survivorship. I adversely possess this property and I have a deed to it and it's mine.
I agree that she could have done that. I disagree that it's required under the law. I think that adverse possession is a very unique concept. And it's something that allows, like, it's special. It provides an opportunity to not require the same.
Well, but doesn't this go to the hostile element of adverse possession? I mean, if she's not saying I adversely possess this property in the midst of years, nearly a decade of litigation about this property, then how's everybody supposed to know that she thinks she owns it by adverse possession?
Well, the adverse
It's supposed to
possession,
be open, hostile. What are my other elements am I missing? And if she sits on it and in the midst of litigation about the property, doesn't assert openly that this is her property by right of adverse possession, then I'm lost on where this adverse possession claim comes into play.
it comes in, Your Honor, because the adverse possession claim had already vested under DC law and not in every
Well,
jurisdiction.
but it only vests if the elements of adverse possession have been met. And I guess I'm asking you how she met these elements secretly, quietly, and, sitting there while litigation about the property. I could see if they were talking about, the wedding rings of the deceased parents and it had nothing to do with the property, but everything for nearly a decade is about this piece of property. And for her to sit there and not assert why she thinks she owns it through adverse possession is baffling to me.
Your Honor, there's 2 points there. First, her adverse possession claim was vested in 1997. That was 15 years from 1982 when Lydia Yates
All the
passed
more
away.
reason that she should have
I
said
agree.
something.
The litigation also wasn't ongoing, at least the questions of ownership were not present until 2014. Before that time, and when it was first raised sort of in probate in 2008, all of the complaints were dismissed for various procedural reasons. So it wasn't before the court. She didn't have anything to raise. So in terms of how long she waited to raise it, it was really just 2014. And in the context of this one particular question, there were other questions of ownership that weren't determined in that 2014 order either. Of particular importance, I think, is the question of what ownership Annabelle Yates does or does not own, which
So
the parties have disputed.
Assuming we may not be persuaded by the adverse possession argument, what are your arguments with respect to the res judicata aspects of this case?
Thank you, Your Honor. With respect to res judicata only bars claims in this district based on facts that have already been decided and were necessarily decided in previous litigation. Here, there's no question that title to property that is based on legal instruments, which was the case of the 2016 order exclusively, is entirely distinct than the factual questions that are necessary for adverse possession. We know that that's a fact-based inquiry, requires depositions, parties, it requires figuring out exactly how the owner satisfied all of the elements for that period of 15 years in DC. None of those questions of physical possession ever came up or were questioned in any way during the 2016 court ruling and during its opinion. So there's no way to determine whether or not adverse possession elements had been satisfied prior to that court order, again, prior to even 1997.
Well, they didn't come up because even though the question of ownership of this property was before the court, and even though it was framed as a question of whether Rita Eunice Yates and her estate had an interest in common or a joint interest with Frank Yates Jr., she did not raise any claim of adverse possession and total ownership. And the judge, as a result, seems to have found, I understand the judge to have found, that, quote, Rita Eunice Yates's undivided ownership interest in the subject property as a tenant in common would remain with the estate of Rita Eunice Yates, rather than pass to Frank Yates through the right of survivorship. It seems to me she's, by failing to raise a claim that she could have raised then, that she owned the property in its entirety, she has accepted to be bound by the judge's determination that she owns the property in common with Frank Yates. And she had every reason to raise it, because the underlying fight to raise adverse possession, because the underlying fight at the time was whether the court would order the sale and of the property. And she basically lost that fight, and as a result, the court did order the sale of the property. It seems to me res judicata should apply here. The issue is ownership, and in particular her ownership rights, because if she owned the property outright, then she could have prevailed on her claim that the property should not be sold. And instead she didn't raise that for whatever reason. Why isn't, it seems like ownership was an issue. She had an argument for ownership she didn't raise, and she can't raise it now.
Your
That's
Honor,
the basic notion behind res judicata.
I-
Why shouldn't we?
I again disagree, because I think the question of ownership isn't the right question. I think that you're phrasing that question too broadly in a way that this court doesn't look at res judicata in that way. The
Well,
court really
suppose
looks at
Frank
what is
Yates-
the underlying cause of action and
You
what's
don't
required to
think,
prove.
I mean, she didn't, when the court then orders, and doesn't the court order the property to be sold in 2016?
After this decision, it wasn't done as part
Right,
of this
after this
order.
decision, But as the result of it, that's what this decision.
As a result of it, but it's also, I think, unclear whether or not the parties were aware, at least whether or not Ms. Yates was aware that that was going to be the outcome of this particular decision. Again, I think that there were remaining ownership questions to be determined.
Back in 2016, when the court orders the property to be sold so that it can be as an alternative to partition, which was impractical, I guess. And the proceeds of the sale would then be distributed among the owners in common. Miss Yates, excuse me, Rita Eunice Yates did not say, wait a minute, there's no, that's all completely unnecessary because I'm the owner of this property in its entirety. And she didn't say that. I would really think that she would have said that, don't you think, if she really believed that she had an adverse possession claim?
No,
And
Your
and
Honor.
that if she fails to say it, she's really foregoing that claim.
No, Your Honor, I don't believe she's foregoing it. And a small, just clarification, Rita E. Yates is the mother in the
Yes, I understand.
circumstance. that
Right now,
passed.
we're dealing
She
with
passed
this
away in
thing that Rita L.
2013.
Yates.
Right. So Rita L. Yates is the one that would
Back
have
then-
been, that
back
would have
then
been
was-
raising this in both 2014 and 2016. The parties are complicated, the names
All right, I may
overlap.
have the dates wrong, but.
Sure.
Yeah.
So here, Your Honor, her vesting of adverse possession, her mother's vesting of adverse possession back in 1997 gives them valid claim to the title. That can't be taken away except for under any other similar ownership rights. So here, failing to raise this doesn't just remove her rights in the property. It doesn't remove her ownership the same way it wouldn't remove other ownership rights.
But she doesn't get to sandbag, right? I mean, the trial court.
Respectfully,
The trial court looked at the property and said, here's how I'm divvying it up. And you get, I can't remember what the percentages were, but the estate of Rita Yates gets less than 100%. Right. And it sounds to me like what you're saying is because adverse possession wasn't litigated, adverse possession isn't precluded, right? But that's a legal argument, right? And we said in Faulkner, for purposes of res judicata, the nature and scope of a cause of action is determined by the factual nucleus, not the theory on which the plaintiff relies. It seems like you want to rely on the adverse possession theory, but the factual nucleus is who owns this house, right? And the court was looking to determine who owned the house and said, you own less than 100%.
no, Your Honor, I think the factual nucleus is entirely distinct from the ownership questions here. Again, ownership under title questions is entirely distinct from ownership under adverse possession, which is a factual inquiry and is based in equity. Adverse possession is different. It does something special. Adverse possession is always going to upend otherwise valid ownership determinations. Here, that
That may be
cause of-
true, but when the court is deciding a question of ownership, I mean, the whole inquiry into survivorship would have made no sense if, in fact, Rita E. Yates
one of the Yates,
Uh,
Mrs. Yates works.
had acquired total ownership by adverse possession. I mean, the courts, it's hard to believe that if Miss Yates really had a claim of adverse possession, she would not have asserted it at this time. Whether you talk about it as possession by title or possession by adverse possession, or excuse me, ownership by title or ownership by adverse possession, the issue here is ownership.
But the
And-
issue is I think, Your
Yeah.
Honor, she's alleged that she adversely possessed the property, and prior to this court order, she had put it in writing in the District of DC that she owned 100% of the property. So there's no question that she has put into the record that she believes she owned it. The question is whether or not she was absolutely required to bring it at this time. Adverse possession doctrine does not require her to bring this as an affirmative defense,
She
and res judicata does not bar her from
She
bringing
may
this
not, but when
because
she
they're
wants to
distinct.
overturn a ruling on ownership, I mean, what she's seeking to do is overturn in effect or disregard
I think that's correct, but I think that it's in favor of the prior ownership determination that vested automatically in DC under section 16-3301. So what she's actually seeking to do is reinstall the proper ownership that had already vested under this district's rules.
Suppose the judge had ruled, actually, this is a joint, which he could have done, Judge Christian. this is actually a tenancy, a joint tenancy rather than a tenancy in common. So this property, now that Mr. Yates has passed away, there's a right of survivorship. Excuse me, I'm getting all the names confused here. It's possible.
I think I can shortcut you though, Judge. I do.
So
I do. And here I would say the same as just like any other valid claim of adverse possession. Here, the possession that was due to this deed back in 1955 would have been nullified and overridden by the adverse possession claim that vested automatically
So
when
do
the
you think
elements
that
were
after
met.
Judge Christian entered this order in April of 2016, do you think Mrs. Yates could have gone into court and said, well, now I'd like a declaratory judgment that I'm the sole owner of this property because by virtue of adverse possession?
Yes, she could have. The question before you is whether she was required
I
to.
find that really quite hard to believe, but that is the logical implication of your position.
It is, Your Honor. I
Judge
think that
Christian, if
it's,
she went before Judge Christian, I can tell you what his reaction would have been to that.
we were
you know
before
it.
him last
You
month,
know what
actually, in this
He
case.
would have said, why did we just spend, all this time doing this? It would have been, he would be quite nonplussed.
And that is the goal of res judicata generally, Your Honor. Here, I think that adverse possession is particularly distinct because I don't think that the parties always want these claims to be brought together.
So this hinges solely on adverse possession. I mean, if the facts were that in 1997, your client actually bought the property and had a deed, right, showing a purchase. But then there was the 2016 litigation where Judge Christian divvied it up and said, this is your interest and this is your interest. She would have been obligated in that proceeding to say, no, wait, I've got a deed that shows that I bought this property in 1997. You agree with that? It's just because it's adverse possession that she didn't have to raise that claim in 2016?
I think that that's more likely. I still think that it would have to go through the process of what are the facts here? Why wasn't it raised? Why wasn't that something that was discovered? Because there you're looking at legal instruments. And I don't believe that the court in 2016 looked at all the legal instruments that were involved here and made factual findings and legal conclusions. So I don't believe that the court in 2016 did a full ownership determination, but assuming that it had, then I think that we are closer to res judicata because you're looking at legal instruments and this one legal instrument being left off of the record. Unless there was some reason, some excusable neglect
I
for
mean, you're
leaving it
talking
off.
in the passive, like it was left off of the record. The whole point of res judicata is that people who have claims arising from certain facts need to litigate them when the opportunity presents. So this, I mean, the way you're talking about res judicata seems to invert it.
I disagree. I think that it's looking at the distinct difference between legal ownership and legal title and possession of the property that is gained through adverse possession, which is more of an equitable doctrine. And the distinctive factors between them are entirely different. The parties spared no expense here where, for example, let me take a step back. If you're litigating just a simple title claim, that's usually pretty straightforward. It is usually pretty simple for the parties. It is going through and doing a deed search. It is seeing if the parties are going to produce any documents. It is finding out a little bit of testimony about the intent of those documents. It is very straightforward, very easy to manage. An adverse possession complaint is complicated, particularly in DC where the statutory period is 15 years. So you have to establish that for the period of 15 years that the adverse possessor has actually open and exclusively with hostility continuously for the period of 15 years, possess this property in a way that a true owner would.
Well, one way to look at this is to say that Mrs. Yates's failure to raise adverse possession in this 2016 proceeding before Judge Christian is compelling evidence that she didn't have a claim of adverse possession. And I wonder if it's even a waiver of such a claim. When somebody comes in and says, I'm a co-owner with you of this property, and as a co-owner, I want to assert certain rights, and including not only the right of survivorship, but have this property sold so that I can, recognize my share of it. And Mrs. Yates says, well, we're co-owners, but under the governing document, we're co-owners, but not but not joint tenants.
I don't believe her argument was that we're co-owners. I believe her argument was no Frank Yates Jr., you have no rights to my mother's estate.
Right, and, but.
And I think that's the only question she thought was being litigated at the time. And that's certainly the only question that Judge Christian, Judge Christian answered. There are other questions of
Well, he
ownership that the
answered-
judge
he answered-
did not answer. Again, including the question of whether or not
But she-
Annabelle Yates.
Well, if that's really, I mean, we have no record, of course, but if that's really true, that she thought this whole proceeding was a very narrow question. I mean, it's hard to believe, given that the purpose of this was to enable the sale of the property for the benefit of Mr. Yates, not her.
The record reflects that there were many other claims raised by Ms. Yates and by her mother before her. And that includes that they believe that Lydia Yates had basically given her the rest of the property. Lydia Yates is 50% of the estate when she passed in 1982.
I mean, I'm thinking, say there's a landlord tenant case, right? And I'm the tenant and the landlord says, you've breached the terms of the lease. You know, you're having tap dancing classes at midnight and you're not allowed to do that in this property. And so I get evicted, right? And then I want to come back and say, well, actually, I adversely possessed this property. I'm actually an owner and I want to litigate that. Even though I've already been evicted from the property as a tenant. You don't think that I had an obligation to raise my adverse possession claim at the time of the eviction proceeding to say, wait a second, I'm actually an owner. I'm not even a tenant. You can't evict me.
No, Your Honor, I don't. I don't believe that there's any requirement under the adverse possession doctrine to raise it as a defense. And there, I believe, again, likely, without knowing more of the facts, that res judicata would not bar that claim because those are entirely distinct causes of action based on entirely distinct elements that would be proven for both claims and entirely distinct factual findings.
All right, Ms. Grimm, I think we have been informed of your argument on this point.
Yes, thank you.
And we will reserve your 2 minutes for rebuttal as well.
Thank you.
Right, Ms. McGee. I think that you said that you all were going to split the 15 minutes evenly.
Yes, we are.
Okay, so what does that put our clock at? 7.5 minutes.
Thank you, Your Honor. Good morning, Your Honors.
Good morning.
Deidre McCann on behalf of Angelo Yates. The appellant here is claiming title to the property by adverse possession. And it's our position that she's not entitled to the property by adverse possession. And even if she had at some point was entitled to the property by adverse possession, she waived that entitlement when she failed to claim it when the issue of property ownership was before the court. She's barred by res judicata, and I think that the lower court was correct in barring her by res judicata. There was litigation regarding the ownership of the property for nearly 10 years. There was complaint for partition of the property, counterclaim for sale in lieu of partition, motion for sale, all of these actions that were going on for 10 years. And at no time did the appellant raise the issue or say that she had the right to own the property because she had adversely acquired it. In addition, when she did, after the Judge Christian's order in 2016, she waited 4 years to file a claim for adverse possession. And then even after she filed that claim, the appellees actually, defendants filed a motion to dismiss. She did not respond to that motion to dismiss. As a matter of fact, the judge even contacted her attorney at the time and asked, was there going to be an answer filed or opposition filed, and waited 2 weeks before he gave the ruling. And at that point, he gave the ruling, partitioning the property 50% to the estate of Lydia Yates and 50% to be divided between the estate of Annabelle Yates, Frank Yates Jr., and Rita Eunice Yates. So at that point, it's our position that she is barred by res judicata. I know that it seems that the appellant wants to put the onus on the judge to bring up the question of adverse possession. If you have a claim, it's the parties who wants to assert the claim. It's their duty to assert the claim. And she did not. And it's our position that she never had the right to possess the property by adverse possession anyway, because the property was never owned. In order for the property to be acquired by adverse possession, it has to be actual, open, notorious, exclusive, continuous, and hostile. And it was not owned hostile. This was a property that was sort of like the family home. And even though the appellant lived in the home that entire time, there was no indication that she felt that she owned it to the exclusion of the other parties too. And so the fact that she lived in it and paid I think she paid the mortgage on it, of course, she's living in it. So of course that makes sense. However, there was nothing that she did that gave notice to the other parties that she thought that she owned that property exclusively. And under Smith v. Tippett at 569 A. 2nd, 1186, this Court of Appeals, it's a 1990 case, says that there is a presumption that occupying the land of the other does so with the latter's consent. Accordingly, adversity must be established by clear and convincing evidence. And in this case, is our position that she never made it clear and convincing that she was entitled to, or that she believed she was entitled to this property to the exclusion of the other parties. And so therefore, while it's their position that the title vested some time ago, she never met the requirements of adverse possession. So she can't now come in and say, well, it vested 15 years prior, and so now the question is moot, because when they came before Judge Christian, the whole issue was about ownership of the property. And this is what she's arguing now, that she owns the property through adverse possession.
Do you have any comment on Ms. Jennings, what I understood to be her statement that Mrs. Yates did not have any knowledge about the ultimate purpose of selling the property at the time of the litigation before Judge Christian? Perhaps I misunderstood it, but that's what I thought she was saying earlier.
I can't believe that to be the case when she was involved in the litigation regarding the sale of the property, and actually was directed to sell the property, to allow the property be shown and to be sold.
That's what I understood.
Yes, she did not do it, but she was definitely part of that action. And so she would have known that that was the case. And so to say that now, well, I really own the property by adverse possession, it seems incredulous to think that if you have that right, that you don't assert it when you know that there is the ownership. That's what's being litigated, the ownership of the property, and
For purposes of selling it.
for the purposes of selling
Who
it.
would get the proceeds and so on and so forth.
Absolutely, absolutely. And so not only did she, and I don't want to take up all of the time, but not only did she not assert her right during the 10 years of litigation regarding the ownership of the property, even when she did finally say, oh, okay, I have a claim of adverse possession, and the defendant said, no, they're going to file a motion to dismiss, and they filed a motion to dismiss, she didn't even respond to that. So, at that point, and when given the opportunity to do so, she did not do so. And so it was clear that the judge was correct in determining that, the case should be dismissed based on res judicata. And actually, that was the reason why, that was the basis upon which the defendants were asking for the dismissal, was based on res judicata. So if she had this claim that,
It was a counterclaim for sale in lieu of partition of the property in the litigation before Judge Christian.
yes, and that was part of the litigation for the 10 years, the counterclaim for sale in lieu of partition, a motion for sale, a complaint for partition of the property. So it was plenty of time. She had plenty of opportunities to at some point assert adverse possession if she really believed she owned the property. She had acquired the property adversely, which we contend she did not, because there was no, it was not a hostile possession of the property, and she has not shown by clear and convincing evidence that she had acquired the property by adverse possession. But even if she did, and again, we say she didn't own the property by adverse possession, if she was entitled to it, she lost that entitlement when she didn't defend on the many occasions that she could have. And to now come back and I know a part of the argument is that, well, these are two different things. You're arguing two different things, but even if it's not if you're not arguing the exact under exact theory, the bottom line is the ownership of the property. And therefore she's required to bring any claim, not just the claim if they're saying they own it by inheritance or whatever reason that she was required to make any claim that would negate their claim of ownership at the time that those issues are being litigated. Because if not, basically what you have, the whole doctrine of res judicata is to conserve time, to not waste the court's time, to prevent trying to find here. Well, basically to prevent the courts from giving different decisions, but different outcomes based upon the same facts, and so if you allow a person to, if she's allowed, we're allowed to save the argument of adverse possession to a later date, then basically the court will be faced with someone coming in and I'll make my one argument today. And if I lose on that, I'm going to come back under another theory and I'll make the argument for the same, basically for the same result. And so it's our position that she had an obligation to raise all issues. There's all defenses or all arguments that she had to support her position of ownership, whether it be she inherited it or she got it by adverse possession. She was required at the time when the issue was being decided about ownership of the property to raise all arguments that she had related to that issue.
All right. Thank you, counsel.
You're welcome.
All right. Mr. Gormley, did I pronounce that correctly? Gormley, I'm sorry, Mr. Gormley.
Good afternoon. May it please the court. My name is Brian Gormley. I'm the person representative of the estate of Lydia Yates, as well as representing Dolores Yates and her role as person representative for Frank Yates's estate. I just wanted to highlight a couple of points, particularly given the sort of the relative dearth of questions of my co-counsel here. A couple of clarifications. Number one, or points to highlight. Number one, I would point out that the 2014 deed from the estate of Rita E. Yates to Rita L. Yates doesn't evidence anything. In fact, it's quite consistent with, in terms of a public record or adverse possession, it's quite consistent with tenants in common. The Rita E. Yates estate can only convey what it has. If it has a 16.66% interest in a property, then that's what that deed conveys. It's not any more than that. It's just that piece of ownership. So I don't think that argument has any legs to the extent that we're relying on a public record to demonstrate some sort of hostility or otherwise. Secondly, and very importantly, in that 2000.
Ask a question, theoretical question. The deed conveyed only a portion of the estate to Rita L. Yates, or am I getting the E's and the L's?
I remember it by E being first and L being second in the alphabet.
So if it only conveyed a portion of the estate to Rita E. Yates,
Rita L.
Rita L. Yates. Could Rita L. Yates adversely possess that portion as well as the other portions that weren't conveyed under a theory of adverse possession if we were persuaded?
So if I understand the question correctly, and I'm not sure that I do, I believe your question goes to tacking,
Mhm.
meaning does Rita L. Yates have a claim via the deed she received from Rita E. Yates to go back in time to tack for 15 years
Correct.
and all the other criteria in adverse possession?
Correct.
I think we would contest that in a substantive merit-based hearing on adverse possession. I'm not sure.
But I guess I was asking it theoretically. I know you would contest the existence of an adverse possession under any theory here, but but if they could prove, it could be proved through tacking if the factual basis were sufficient.
So in a vacuum,
Mhm.
if A owns property, conveys it to B, conveys it to C, and it's a shed, right, in a boundary dispute, something more aligned with adverse possession, then C can tack off B and A's ownership for a period of, in this case, 15 years. So in a vacuum, that is theoretically possible.
And here, the facts were insufficient for any tacking theory because.
Well, I think there's some continuous possession issues. I'm not so sure that there is a privity between mother and daughter, just because of the deed. That the appellant would argue that the adverse possession has been perfected prior to that deed in 2014. So there's some holes there that I think we would want to challenge.
Okay.
Okay, second point, very, very important in that 2014, 15, 16 litigation, the LIT matter for Judge Christian. If you look at the pleadings, Ms. Yates did raise as a factual nucleus question here, right? The claim that Mr. Frank Yates did not own any piece of the property. Has nothing to do with a deed question. It related to the factual basis of his potential buyout in the 70s from a mortgage that was taken out in that time. So the point is just that there was a common nucleus of facts here. She did raise, in fact, more than just an interpretation of a deed, but rather the actual ownership of the property. She also conceded Lydia Yates's interest by filing a motion to dismiss for insufficient service on indispensable parties all the way back in 2010. Lydia Yates was determined by Judge Christian to own 50% of the property. And the original 2008 partition action didn't include all of the heirs of the Lydia Yates estate. So she has in fact conceded the Lydia Yates ownership by implication, as well as raised these sort of ownership issues, albeit not through adverse possession, which of course, as a timing matter, is very suspicious, right? She has done everything that the two Rita Yateses have done everything they could from 2008 litigation on to hinder, delay, stall this actual sale of the property. This adverse possession claim only being filed in 2020, well after all of these other actions have occurred. To Judge Gutman's point, the 2008 case was a partition case. She had plenty of notice that title ownership was potentially at issue. And of course, as noted, the December 2016 order, which was not appealed, said, move out, it's time to sell the property. And she didn't appeal that. And I filed a motion for contempt because she hasn't filed a court order to move out and sign a listing agreement and sell the property. I would note at least one other thing. that hasn't been raised yet, and that is just that Judge Irving has an abuse of discretion standard, I think, for his three-part alternative finding that under 12I, Rule 12I, right? Because there was no opposition filed, there's an abuse of discretion. That motion is conceded or can be treated as conceded. And whether this court agrees or disagrees with his decision, that's not the question. It's whether or not he abused his discretion in determining that. His order had three prongs, right? The 12I prong, the adverse possession prong, and the res judicata prong. So just that alone is I think sufficient, regardless of the merits, regardless of res judicata. I don't think he's abused his discretion for all of the reasons we've discussed. This has been a very litigious case. Both Rita Yateses have been well on notice, and they've stalled and hindered the sale of this property for more than a decade. It's gone 15 years now.
Thank you. And unless there are any questions from my colleagues, thank you for your argument, counsel.
Thank you so much.
All right, Ms. Grimm, you have 2 minutes.
Thank you. Your Honor, just to start.
2 minutes.
Sure. I was going to wait for the clock to get fixed. It's fine. Judge Irving did not treat this motion as conceded, so there's no reason to treat this under an abuse of discretion standard. This court's normal review is de novo anyway, but he flatly said he was treating this under the merits and not as conceded. Further to the failure to file any kind of response to the motion to dismiss by Ms. Yates's previous counsel, she discussed that in her motion for reconsideration and why she thought that the summons had never been issued by the court and therefore that the motion to dismiss was improper. And that was her reason, that it was a timing question. And there was a hearing that was scheduled where she had planned to bring that to the court's attention, that the summons hadn't been issued and therefore that she didn't think that she could actually serve the parties properly. And the judge had canceled the hearing. So that was a miscommunication, certainly, but it is clear on the record that it was her intent to file an opposition to the motion to dismiss. And certainly, I think the evidence in the record and through the history of the case makes it very clear that Ms. Yates has never intended to cede her rights. Beyond that, I would say that the question about Ms. Yates's knowledge prior to 2016, I think that there's a distinction here between Mrs. Rita L. Yates and Mrs. Rita E. Yates. And certainly Ms. Rita L. Yates takes on the ownership as personal representative of the property, which was the condition that she was in 2014 during when this was happening. Her mother passed in 2013 and had been dealing with all of the legal proceedings prior to that time. And again, most of the time she was not represented by counsel. And when she was, it was highly inconsistent, which also explains her lack of responding and timely responses to many different documents. In addition, Your Honors, I want to point you to just one case that sort of talks about, I think more particularly this issue that we mean when we say, why does res judicata not bar this claim? And that's Mala versus Sanders. And Judge Glickman, I believe you were actually on the panel for this matter back in 2009.
Excuse me, I didn't quite catch what you just said.
Mala v. Sanders is just one case I want to point your attention to. And this was decided back in 2009. And this is a claim where an individual brought two different ejectment claims against his tenant under different laws. And they found it wasn't barred by res judicata because the issues that needed to be cited, the factual issues, hadn't been fully decided in the first claim. And with that, the only other thing that I would like to say, since we haven't talked about the merits at all of the adverse possession claim, and certainly what would be required to sufficiently plead, I would point your court to DC Code section 16-3301, which even sets a different standard for pleading under adverse possession. Again, it is a unique doctrine. The only thing that you're actually required to plead is that you held the title and it was vested by adverse possession, and everything else is pled and proven later in the facts. So if there's any concern about the sufficiency of the pleading, again, I just don't think that there should be here since it was decided solely on the basis of res judicata, but we'll point you there.
All right.
And if you don't have further questions, Your Honors, I thank you for your time.
All right, thank you. We thank counsel for your briefs and arguments in this matter, and the case is submitted. Our third and final case this morning is RENE ZELAYA versus ALFRED Strange. All right, good afternoon, council. Are you ready to proceed? And I see a number of council at appellee's table. Could you just let the court know how you plan to divide the time for argument, if you plan to divide your argument time?
Just myself, Your Honor.
All right, thank you.
Let's go.
I don't know if it could adjust. Is that a good height for the podium for you, council? I don't know if it goes any lower. There we go. And the microphone can be adjusted as well. There we go. All right, thank you. All right, council, are you ready to proceed?
Thank you. Good afternoon, Your Honors. May it please the court. My name is Mark Fiedler, and I represent appellant RENE ZELAYA. The principal issue on appeal is whether appellee Alfred Strange had control over the workplace at the Riggs Road project sufficient to be deemed an employer under the Industrial Safety Act who owed a statutory duty to furnish a reasonably safe place of employment to Mr. Zelaya. The evidence of record viewed most favorably to Mr. Zelaya compels an affirmative answer to that question. Rather than repeat the many aspects of Mr. Strange's supervisory authority that we cataloged ad nauseum in our briefs, I'd like to focus today on a particular aspect of his job duties that demonstrates the requisite control under the ISA and distinguishes this case from Presley.
I was going to ask you about Presley, counsel.
I don't know
So
why,
I'm
Your Honor.
interested in seeing how you would distinguish this
Sure.
case from Presley.
Page 283 of the appendix and relatedly page 290 indicate that Mr. Strange was obligated to, quote, require correction of observed situations that are potentially dangerous to workers, the public, and the project, close quote.
And this is from DDOT's standard operating procedures. Is that what you're quoting?
It's the construction manual.
The construction
Which-
management manual. Yeah.
The construction management manual, which is in the record at the pages I indicated, and which Mr. Strange testified under oath in deposition accurately reflects his job duties.
So you would say that that language distinguishes his role from the role of the consultant in Presley because why?
Yeah, because what it shows is that Mr. Strange had not merely the authority, but the obligation to command the contractor to rectify an unsafe situation. And why is that significant? Because it shows that Mr. Strange had the power to direct the actions of others, which is a hallmark of the concept of control.
Whereas the consultant in Presley had to sort of run it up the chain or refer it.
Exactly.
To
They,
others.
both the consultant in, to be fair, the consultant in Presley and Mr. Strange both had authority to stop work for imminent dangers that they observed. But beyond that, if the consultant in Presley, if it's in inspectors saw an unsafe situation, they were to document it, send that documentation up to GSA, and then GSA was to review that and send it to Grimberg, the contractor. And as the court pointed out, the consultant did not have, shall we say, enforcement authority in and of itself. But the provision that I quoted a moment ago shows that Mr. Strange did. He was an enforcer.
So
not just
sorry,
an
you,
observer.
your folks, I just want to make sure, it's been a long morning, so I want to make sure I'm processing the language that you're pointing us to. You're looking at the require correction language. So it's not just the stop work provision, which is in Presley, but it's also the require correction. I guess, I mean, yes, I see that. What makes this more challenging for me is that that language is embedded, right? We're looking at the construction management manual. So this is an internal DDOT document that Mr. Strange, as you say, describes his job obligations. And it says, I just want to read out the full paragraph, right? And then one other portion that caught my eye. The construction manager is responsible for monitoring the contractor for conformance with contractual safety requirements and shall bring all observed violations to the attention of the contractor. The construction manager is not responsible for the safety of the contractor's workforce and methods of construction, but shall require correction of observed situations that are potentially dangerous to workers, the public, and the project, and shall order the termination of work that poses a serious and imminent danger to public safety or substantial property damage. So it doesn't seem to say, well, it seems to point in a lot of different directions, right? I mean, it seems to say, look, if you're there and you're on site and you see something, you have to do something. You have to stop the work, right?
More than stop.
Well, but before it talks about the stop work, it talks about the construction manager not being responsible for the safety of the contractor's workforce, but then also says they're obligated to require correction of observed situations. So once again, it's not that you have kind of the baseline obligation, worker safety is your job, right? It's not your job. But if you're on site and you see something, you have to require correction. Is that fair? Or, I mean, how are we supposed to read this passage?
There's no doubt of what it says, and the passage that you talk about it's basically civil construction's responsibility to for the safety of its workforce. But that's not unlike what was true in Trout or in Velasquez. The way I reconcile, and I urge the court to reconcile, is the fact that the contractor, civil construction, was responsible for the safety of the work and the workers in the passage that you quote and elsewhere, by the way, does not preclude Mr. Strange from being responsible for the safety of the workplace, the work site. He had a much broader view. It's not just the workers, it's the public, it's anybody else that may be endangered. That was his purview. And the two are not mutually exclusive. I mean, the Industrial Safety Act takes a belt and suspenders approach to safety. It imposes the duty not on those, such as the contractor here, who had control over the workers, but also those, such as Mr. Strange, who had control over the workplace. The two are not mutually exclusive.
Right.
One does not preclude the other.
I don't think they're mutually exclusive. It's just, I'm trying to figure out sort of how much control is needed, right? And so this passage is one passage that gives some control, but is it enough control, right? Because there are distinguishing factors in Trout and Velasquez, you know, about ownership of the property and right. And so it just gets kind of fuzzy in this middle place. And it's certainly so just to make sure that I understand, one could say there's control over the worker, or one could say there's control over the work site. And your argument is on these facts, Mr. Strange had control over the work site.
Yes, and in none of these cases, or well, let me back up. It would be rare for someone, say in Mr. Strange's position, or in the position of the defendants in Velasquez or in Trout, or in Fry, to have absolute authority over safety, because it blurs the line. Once you make the person who is not the common law employer, in other words, Mr. Strange is not the common law employer.
Right.
Once you make that person responsible for the safety of the workers, now it's blurring the line about how much control over the workforce there is, which could make that, which could subject that individual like Mr. Strange, a common law employer who's vicariously liable under respondeat superior for the torts committed by the workers, or could impose workers' compensation liability.
But if
So
we're
almost
focused
always-
though on workplace safety, not workforce, right? If we're control over the workplace, not the worker, right? It's a whole lot easier to go beyond the common law understanding of what an employer is if the entity, and everything until today has been an entity, not an individual like Mr. Strange, owns the site, right? So, you know, to your point of, oh, well, you know, we can't have this collapse into the common law understanding. For sure, we can't. That's clear that the Industrial Safety Act doesn't want us to, but I don't know to date that we've said, oh, you can have workplace employer status, control over the workplace when you don't own the property, when you're, you know, this kind of middle level construction manager who clearly has some obligations, but doesn't have kind of total control over safety at the work site, right? His control is if he sees something, he's got to do something about it. Is that fair?
Not exactly, Your Honor. In going back to Martin versus George Hyman, the defendant was a general contractor, didn't own the site. Fry was a general contractor, didn't own the site. In Velasquez, one of the two defendants was the property manager.
I don't think Fry, we're dealing with who was the employer. It seemed, I thought that was conceded or not litigated. The identity of the employer under the ISA in Fry.
The identity of the
Right, this question, this legal question of who is the employer under the ISA, I don't recall that being litigated in
there's no
Fry.
elaborate discussion of it in the
Right,
opinion.
and Hyman, isn't Hyman a criminal case? Is that's the initial case? Or am I thinking
No,
of
it's a court
Hutchinson?
case.
I'm thinking, no.
And there's no discussion in there either, and it's
Right, I mean, Hyman's talking about, so, I mean, I
but
just
the
don't,
fact of the matter is, the court held, at least in Fry, the court assumed in Martin, but the court expressly held in Fry that the general contractor owed a duty, statutory duty under the ISA.
right, but
to-
but I think we have to keep the duty of care separate from the employer status under the statute, no?
No, once you're deemed an employer under the statute, you owe the statutory duty.
Oh, I thought our cases said something different, but I'll look for that. I wanted to get back to, my question was more factual about, do the facts in this case show more than he had custody and control over situations that he observed? Do you see what I mean? Right, because just to point you to the other part of the construction manual, management manual, I was looking at section 9 on 234 of the joint appendix. which says, look, the subject of safety on a construction project is complicated and requires diligent study by the construction manager. In general, the construction contractor is solely responsible for safety of the work, including work done or materials supplied by subcontractors, consultants, and vendors. It cannot be delegated to other persons. The contractor is responsible for complying with the requirements for safety and accident prevention.
Yeah.
Right.
that's-
So if you read that in conjunction with the passage that we were looking at earlier, it's sort of, it puts Mr. Strange's control in some context, and it seems smaller.
Yeah, it's not absolute. Neither was the one in,
But you think it's enough?
well, for all the reasons stated in our brief, and I can start going through those if you'd like, but I don't know that's the best use of the court's time, but I could tell you, look at Trout and Velasquez. They didn't have absolute control either, and I think it was in.
Right, but they had
Velasquez.
ownership of the property, right? So.
No. Remember, again, Velasquez was both the owner of the property and the property manager, and the court expressly said that both of them.
They do,
owed
but
a
they
duty.
don't discuss it, right? Like it's in there. But if you're talking about, right, it's Essex and then it's also Zalco. And we just say Essex and Zalco are employers, and there's no analysis about Zalco.
Right, but well, the court earlier in the opinion laying out the facts explains what the obligations of the various parties were, and
Right, but
the one that I was going to mention is
okay.
And this would apply both to the owner and to the manager in that case, that it says, and correct me if I'm wrong, that the contractor was wholly and totally responsible for safety. And yet the court ruled, despite that both the owner and the manager owed a duty under the Industrial Safety Act, although the court ultimately concluded that there's sort of no causation element connecting that control with the accident. But the fact is, like I say, in almost none of these cases does the defendant have absolute control, both of the workplace and over the contractor's safety. And here's the other thing. Remember, we're talking about an industrial safety statute that says if you have control over the workplace, you owe this duty. It would make very little sense. I would be against public policy for a defendant to voluntarily say our responsibility for safety goes to the contractor. You can't do
So
that.
you're giving me a sec, and I know I'm keeping you over your time, but I have an issue that I want to bring up with the district, and I want to give you an opportunity to respond to it first. So your public policy argument point is a nice segue to that. So the Industrial Safety Act, it's enacted in 1918, right? It's before the administrative state exists. And the point is, we are having all these accidents in the District of Columbia. We want to regulate somehow, except that we don't have agencies to promulgate regulations. There's no OSHA, right? We're going to enact a criminal statute that says you can be criminally prosecuted and subject, you can be convicted of a misdemeanor and jailed and fined if you, employer, don't have safety measures in your workplaces and for your workforces, right? And that statute.
Are you asking me a question?
I'm about to. That statute, sorry, there's a long lead up. That statute carves the district out, right? And says the district can't be an employer. Right. And so I'm curious to understand why you think that an employee of the district can be an employer if the statute doesn't allow the district to be an employer.
Well, we litigated this in the appeal the last time a few years ago, and the court addressed it in the memorandum opinion and judgment. but I wasn't prepared.
I saw where it said that Mr. Strange couldn't be an instrumentality. But that's a different question.
Yeah,
Right?
well, but the statute, if you, I don't have the statute in front of me, but it talks about individuals like manager, foreman. Not corporations or partnerships or entities, although it includes those too, but it specifies.
I see that, but
individuals.
let me put a finer point on it. If a district employee like this D.J construction manager weren't doing his job under the construction management manual, do you think the Industrial Safety Act gives the district the authority to prosecute their employee for not doing their job?
I suppose so. I mean, it's sort of beyond the scope of this particular appeal. But
And to your public policy point, right? Say now we're talking about a private entity, some big construction company, and they delegate safety compliance as has been done in this construction management manual to a mid-level employee. And then someone wants to sue the construction company to say, you didn't do what you should have done to provide, a safe workplace. Could the construction company then say, we're not the employer, right? We delegated all of that to our mid-level employees. So I know you want to go after our deep pockets, but I'm sorry, you're out of luck. We're not the employer. Would that seems to be contrary to the public policy of the ISA.
yeah, it's an interesting question. It seems to me that the court in none of the cases under the Industrial Safety Act that have been reported so far have directly addressed this issue of vicarious liability under the statute. It seems it's been assumed when
But maybe we haven't gotten there because that mid-level person isn't an employer. Maybe the control flows up, or, we've only looked at entities to date. And so now this is the first case where you're asking us to look to an individual. And you can't sue the entity because, in this instance, for two reasons, no pre-suit notice and because the district can't be sued under the ISA.
But entities act through individuals.
Yes.
And so, for example, it was Diamond Construction in Fry, but there was a particular guy named Barnes, who was the on-site guy for Diamond Construction. And he was the one at the job site. He's the one who made decisions and gave orders to the subcontractors, subcontractor, and Diamond Construction was the one that was held to be an employer, statutory employer under the ISA. Although I take the court's point, there's not much analysis in there as to why that's the case. But isn't that going to be true of any of these other cases in Velasquez, Zalco, and I forgot the name of the Essex? They act through people. They're particular individuals who.
Right, but the individuals weren't sued. It was the entities were.
It's the court up till now is. Everybody seems to have just assumed that the entity has sort of responding as superior liability for the acts of its agents. And so that's the best that I could do. There is no further analysis in the case law right now.
Could you?
Sorry,
I'm
go
sorry.
ahead. I was just going to say, mind you, the district hasn't made any of these arguments. So I sort of,
Say that again,
the
please.
district hasn't made any of these arguments. So I've sort of blindsided you.
Not on appeal, but they did make them to the trial court, which rejected them. This issue about, but he's just an individual, and there's no case law showing an individual could be liable. If I'm not mistaken, I think it was on this round of summary judgment that the trial court said no, the fact that he's an individual and not a corporation doesn't cut any ice, and the district didn't cross appeal that. So I think that's by the boards.
No, that's okay. I think you've addressed what I was going to ask.
Did you want to address the argument sort of raised a little later in this proceeding about whether the Workers' Compensation Act precludes recovery under the Industrial Services Act?
Frankly,
Safety Act.
I was going to submit on a brief on that, but I'll hold it off till my rebuttal to see if the district raises it, I'll respond. But I'd like to wrap up because I'm way over my time. But keeping in mind that a remedial statute such as the Industrial Safety Act is to be liberally construed to effectuate its salutary purpose, this court should rule that Mr. Strange had control over the workplace sufficient to give rise to a duty under the Industrial Safety Act. And because, as noted in Trout and in Presley, this is an issue for the court alone to decide. It's an issue of duty. The court should make clear in its ruling that Mr. Strange owed to Mr. Zelaya a statutory duty as a matter of law. Okay.
All right. Thank you.
Thank you.
May it please the court, I'm James McKay and I represent Alfred Strange. It's a very horrible accident, but after this court dismissed the case against the district and Mr. Zelaya got considerable compensation, he seeks additional compensation by suing a mid-level district employee, Mr. Alfred Strange, which he can only do if Mr. Strange is called an employer under the Industrial Safety Act. And as court has mentioned, Judge Easterly has mentioned, no case has ever held that an individual employee is an employer under the Industrial Safety Act. It would also be, it's rather odd to say the district government is exempt, excluded from the Industrial Safety Act, and yet an employee of a mid-level employee like Mr. Strange is. And that seems a very odd interpretation of the statute. I mean, Mr. Strange did not have the requisite custody or control of the work site to make him an employer. Civil construction and not Mr. Strange controlled and supervised Mr. Zelaya and determined the methods of construction and was solely responsible for the safety of the work under the construction management manual.
We seem to have a few kind of conflicting provisions of the construction safety manual. We have the provision that was similar to the provision in Presley that we said may not be sufficient here. It's as if some provisions say that Strange had control and the ability to do things on site. Some provisions seem to say he had to kind of run it up the flagpole to his superiors before action could be taken. How do we harmonize those two? Is it if any provision gives him authority for safety over the workplace or the employees, then therefore under the Industrial Safety Act, he would be an employer?
Your Honor, no, Mr. Strange is very similar to CRSS. If you look at page 885 of the Presley decision, I mean, CRSS had limited authority to stop work in situations that it actually observed imminent dangerous situations. It actually did. But otherwise, it had to report to the contractor and tell the contractor, you fix this. That's exactly the way a normal construction contract works. And that's the way it works here. You have section 9, which is actually the record is kind of funny. It has two numbers, but the appendix 290, section 9 of the construction management manual lays out the responsibilities, the specific responsibilities regarding to safety, and that is given to the contractor here. He's solely responsible for the safety of the work. The fact is that the construction management manager has exigency authority. If he sees something that horrible is going to, like somebody is going to fall into an open pit, he says, stop don't do that. Put some safety. Then he tells the contractor, you put some safety coordinates around that pit so nobody else falls in it. And
Wasn't that kind of what happened here? I mean, we
No.
had a serious electrical hazard that Mr. Zelaya flagged. Didn't Mr. Strange have the authority to immediately stop work, given that highly charged, literally and figuratively speaking, situation?
Well, Your Honor, I would say that first, the record's not clear, but basically what happened on that day is not really that critical as to whether Mr. Strange was an employer. To determine whether he's an employer, you have to look at the construction management manual and see what his actual responsibilities are that would make him an employer. This court in Presley, as I said, he's very similar to CRSS. And this court, I noticed a passage on page 886. This is particularly where an entity does not own the workplace. Liability under the ISA must be grounded on fact showing authority and actual control. I mean, the
But
actual
why-
control is in civil.
Right. Why isn't there actual control beyond what there was in Presley, where it's not only that Mr. Strange has the authority to stop the work, but he has the obligation, he shall require correction of the observed situations, which I think is distinct, right? From in Presley, if I'm correct, the reports would go to another contractor and that contractor had the obligation to correct the situation. So that seems materially different.
Your Honor, I think that Presley is similar because Presley, in either case, Mr. Strange and CRSS could not directly order the employee. They had to say, tell the contractor through whatever channels the contractor has to fix this.
Where does it say that? I mean, it sort of sounds like he does have the authority to order the contractor. He shall require correction of the observed situations, and he's the contract manager, right? He could say, we're not paying you and you have to stop work and you can't do anything until you fix this.
Your Honor, the authority of Mr. Strange is to stop work if you have an exigent situation, which was the same as Presley.
Hold on, let me just stop you. Let me stop you right there, though. That's not quite right, right? It's the construction manager shall require correction of observed situations that are potentially dangerous to workers, the public, and the project. And then separately, shall order the termination of work that poses a serious and imminent danger to public safety or substantial property damage. So there are two provisions. And one of them is stopping work in exigent circumstances, but the shall require correction of observed situations is only for situations that are potentially dangerous, not imminently dangerous.
Your Honor, in Presley, this court pointed to 5 factors, and each of them are the same here. Strange did not own the work site. He did not have the authority to promulgate regulations safe for safety. He had only limited stop work authority and only if there was a danger to public safety. And he did not normally act directly to rectify safely violations.
I understand those are the facts in Presley, but we didn't set out a 5-factor test in Presley. We didn't say you have to hit all of these marks.
No,
we just identified those as in a totality of the circumstances kind of analysis and said that's what's pushing us in this case to say there's no this entity doesn't have the status of employer.
Well, Your Honor, the 5th factor is that he's no obligation to maintain a constant presence of the workplace. If you look at paragraph 5 of the amended complaint on record, page 3, you'll see there's a myriad of things that are going on in that construction site, all sorts of things from tree stumps to paving to gutters to sidewalks, and everything's going on. This catch basin was one of numerous things. He can't be there all the time doing everything. The construction management manual actually makes us even stronger case for Mr. Strange because it affirmatively gives the contractor of civil construction sole responsibility over the safety. It requires, if you look
But
at
it, my point is, it doesn't give the contractor sole responsibility, right? It doesn't because of, or, I mean, it says that it does, but sole seems to be a misnomer because of the passage that we've been discussing on Appendix 204, right? Because it's not sole, actually. Mr. Strange, as a construction manager, has these obligations as well. So it's hard to say that it's sole.
It's correct. It says in general, the construction contractor is solely responsible for the safety of the work, et cetera. Now, it also says the construction, the contractor has to create a safety plan. And this is civil construction, has to create a safety plan and page section 9.1, and that the construction manager has to comply with that plan. So Mr. Also is undisputed that Hector Shoto, who is a civil construction employee, was responsible. He was a safety officer. He was responsible for the safety on the work site. This is a civil construction employee. So in addition to the similarity with Presley, we have all these additional arguments, all these additional factors.
Do you think, and this is another question that I had reading the ISA, do you think that more than one person can be an employer for the purposes of the statute?
Well,
or could a person and an entity?
Well,
My hypothetical about a construction company saying, well, we delegated to our mid-level manager, they're really the employer, so you have to sue them. We're not liable under the ISA. Could someone say, well, wait a second, you're the employer and they're the employer, but actually we really want to sue you, the company, because you guys have the deep pockets. Do you think there can only be one employer under the ISA?
Well, Trud case are cases where there were two employers. I mean, I think it's possible. I don't think it's true in this case because you'd have to make a mid-level DC employee an employer under the Industrial Safety Act, and I don't think that's a proper construction of that act.
May I ask you
a
question or two? They may verge on the hypothetical, I suppose. A preliminary question. Suppose the District of Columbia did not have a carve out in the Industrial Safety Act. Suppose that sentence wasn't in there. Do you think the District of Columbia, the district government, or the Department of Transportation, whichever entity we're talking about, do you think that it would be an employer in the circumstances of this case? It owns the property. It can be said to have employed the construction company and its workers to do the work there. It does have the power to control to a great degree, it would seem. Do you think the district under those circumstances, or if you don't like that hypothetical because it involves the government, suppose Mr. Strange worked for a private entity that owned the property at issue. Would that private entity be an employer for purposes of the Industrial Safety Act?
Well, Your Honor, no. And it's even if you had the ownership.
Is your answer no?
I said I would not think that he would be an employer, or the entity would be an employer, because assuming the contract management manual is the same, it very clearly gives responsibility for safety of the workplace to the contractor. And the contractor has appointed a safety officer, Hector Shoto, who is totally responsible for safety.
So it's like an independent contractor situation. But now suppose that's presumptively true, but the employer, the property owner, the company or the district happens to know that that on this property it owns, there is this dangerous situation, and it sees that the contractor that it's employed is going to put one of its employees in this very dangerous situation and does nothing. Would that be a violation of the ISA?
Well,
I had the impression from some of our case law that an owner, for example, who is aware of problems with the site and so forth, could be liable under those circumstances, even where there's an independent contractor relationship.
well,
with the-
in the Trout and Pepco, of course, Pepco said, own the cables and told the employee who didn't have much training, put this screwdriver in this live wire to get out the asbestos, and of course he gets shocked. Now that's, as the court said, the Pepco asserted ownership over the property by making the workers work while on live wires, and which it seemed to me that's a good case for saying Pepco did not furnish a safe workplace. This is quite a different case. It's you have situations which is very similar, nothing identical, but it's similar to Presley, but then it's more. You have a division of responsibilities in the construction management manual, which this court said is just like the contract in Presley. It gives the civil construction authority over safety. It gives them primary, generally sole responsibility. There are some cases, some situations where the construction manager has to do something, like if he sees, eyes a violation, that he has to, he can either say, stop doing that, or he can say, tell the Mr. Constantino, this is a very bad thing. You shouldn't do that. You should have more safety equipment. Here we have a situation where the authority and the determination of whether Mr. Strange is an employer is basically based on the construction management manual. I mean, rather than the individual facts of the case, you have to look at what his authority is to determine whether he's an employer.
See, I was thinking of it in terms of, you have to look at what his actual power is. And one can say that, I mean, what we're talking about here is control. We're talking about power. The statute in broad terms seems to be saying, if you have the power to, and the knowledge to prevent a dangerous situation, and you don't exercise it, then and something bad happens, you can throw that in, then you're in violation of the act. You can be criminally prosecuted for inaction.
Only if you're an employer.
Only if you're, well, right. And so we said, well, what is an employer? Well, it's someone who has control.
Has control over the work site, and the point is that that's what the definition of word control was discussed by this court in the Presley case and also the Trout and Velasquez cases. And the point is, there are these factors. Do you own the property? Do you have the authority to promulgate safety regulations? Do you have anything more than stop work authority or tell the contractor to stop something? Or do you, and all these five factors, I think all are exactly the same here.
So in other words, if the owner of industrial property sees that a contractor it's hired to do some repairs, and the owner sees that that contractor is putting one of its workers in a very dangerous situation and is deliberately doing it knowing that it's dangerous, you have no obligation as the person who's hired those people, or as the entity who's hired those people, to step in and say, stop this. I don't want this employee killed on my property,
Well,
or what have you.
yeah,
Under the ISA.
I think you have that obligation, and so did Mr. Strange, but that doesn't make him an employer. The fact he has obligation, if he sees a violation with his eyes in front of him, to do his best to stop it from occurring, that makes common
So in other words,
sense.
having the obligation and having the power to prevent the accident and the knowledge in the situation to do so is not enough to make the person a quote employer under the ISA.
Well, the question is, if you do have control or custody of the workplace, and it's an all-embracive thing. It's not just a stop work because I see something bad happening. It's a did you promulgate safety regulations? Are you like PEPCO or are you like
Well, in this-
Essex?
In this instance, going back to the construction management manual, right? He doesn't promulgate safety regulations, but has an obligation to meet with the contractor to discuss safety on a regular basis. One could also work into the mix under a totality of the circumstances analysis that he doesn't own the property, but Mr. Strange's common law employer owns the property, right? I mean, you could look at it that way, right? He's the mid-level manager for DDOT, and DDOT is a district agency, and the district owns this property where there are power lines and where this trench needs to be excavated. I'm going to get the construction terminology incorrect. So why wouldn't we look at it in a holistic way like that?
Well, Your Honor, it would be extremely unfair, having acknowledged that the statute excludes the District of Columbia from liability. It does not apply to the District of Columbia. It would be very, very unfair, and I think it would be bad interpretation to say, nevertheless, it'll apply to a district employee.
Well, this is an argument I wondered about, and we've talked about this, why you didn't make this argument in the brief.
I just didn't hear it.
This argument doesn't seem to have been made in the brief on appeal. In other words, I agree with you that if the statute is going to make the District of Columbia, if the statute is going to carve out the district government from liability, you would think that an end run can't be made around that by saying, oh, okay, well, we'll prosecute the employees of the District of Columbia. You would think the district would say, well, wait a minute, that's just renders completely nugatory the exclusion.
Well, I was responding.
But that argument isn't really before us, I don't think, in this appeal.
No, I was responding to Judge Easterly's question. I think it would be odd. I just think that this is an odd case. Never had a case where an individual employee, especially a mid-level employee, like, he's in the middle of everything, whether he could be an employer under the Industrial Safety Act. I think especially when you have.
Well, do you think that if an employer, if a company, private company, say, is an employer under the act?
Yes.
Can now the company obviously works through people, individuals, such as Mr. Strange. Could where the company is an employer, could the individual be sued as well, who's on the scene and who's actually the person through whom the company acted?
Well,
or didn't act when it should have acted?
I don't think the individual would be an employer under the, of course, you can sue anybody, but I think it would be a bad, an unfortunate interpretation of the act, at least in this case, where Mr. Strange's authority was not the embrace of authority that PEPCO or Essex had in those cases, and it was more similar to the authority that CRSS had in the Presley. So
let me give you the following hypothetical.
Pardon me?
Let me give you the following vague hypothetical. PEPCO is the big employer and it hires the construction company in this case. And PEPCO satisfies the definition of an employer with it for purposes of my hypothetical within the meaning of the ISA. And PEPCO could be prosecuted for what happened here. And PEPCO could be sued civilly under the ISA for what happened here. But as it happens, PEPCO is bankrupt and has no money anymore. And so the prosecutors and the district say, well, who was the person at PEPCO who was actually responsible for what happened here, for PEPCO's inaction? Could they sue and prosecute that individual employee at PEPCO?
Well, we're talking about criminal prosecution or civil?
I'm talking about prosecutions under the ISA, both. Both civil lawsuits. I didn't think it made a difference.
The ISA is a criminal.
Maybe I missed something. I didn't think it made a difference.
Well, all right. I don't think that person would be an employer under the ISA. An employee of PEPCO, even if PEPCO's bankrupt, would not be an employer. And we have a lot.
Even though it's that person who is the actual human being, who has the control, so forth, the power that Pepco, that makes Pepco the employee.
Well, that the person would not be the owner of the property like
Uh-huh,
Peppo was
right.
in Trout. He wouldn't be promulgating safety regulations like, you know.
I mean, you may be right. I just want to work this thing through.
Yeah, I think that you have to, the question here is who is an owner of the ISA and the statute says,
Well, you don't have to be an owner.
pardon me?
You don't have to be.
Well, who is an employer,
Employer.
pardon me, under the ISA? And it's the question is whether or not the person has custody or control of the employee or the work site. And in this case, Mr. Strange had neither. He didn't, undisputedly, he did not have any custody or control of Mr. Zelaya.
You have to have total control over the work site or over the employee in question
Either.
to fall within the category of employer.
Well, it says or, so, but in this case, I'm just cutting it down. That undisputed, he did not have custody control over an employee.
Right.
Right. And the question is, did he have custody and control over the workplace? And the answer is no, he didn't, because he didn't have his authority was similar to that of a CRSS and Presley. And more than that, the construction management manual very specifically gave authority for the safety of the work site to civil construction. And that's section 9.
Suppose somebody said, well, look, as a de facto matter, regardless of what the manuals may say about, we want other people to have the responsibility. As a de facto matter, Mr. Strange had sufficient control in the circumstances to have protected Mr. Zelaya from harm had he exercised it.
Again, Your Honor.
Why is sufficient control to do that not enough to constitute control for the purpose of the Industrial Safety Act?
The question of whether a person is an employer does not depend on a single incident, or it depends upon the authority. And here the authority is clearly specified in the construction management manual. And you have to look at that as to determine the question of whether or not Mr. Strange is an employer. I mean, what he did or did not do in a particular day does not really determine whether he is an employer.
Well, that's what I'm wondering. Why not? I mean, suppose
Because-
somebody says, look, for everything that really matters, this man, Mr. Strange, at this particular time, had all the control that mattered because he was informed that there was a danger. He was told by more than one person. This was a serious danger. He had the power, the de facto power, and he was authorized by the manual to prevent that harm from occurring. He has all the control over the workplace as was as he needed to prevent this harm. Why is that not enough for purposes of, given the purposes of the ISA? Why does he have to have other control in addition that has no bearing, frankly, on whether the harm will be prevented or not?
Well, Your Honor, the fact that in hindsight, Mr. Zelaya was asking them to stop him. He told him, you've got to talk to your boss, Mr. Constantino. And then they left it at there. But that doesn't really answer the question.
They told him that, look, we've tried to.
Pardon me?
They did tell him, Mr. Strange, you know, we've tried to get our.
Well, he was told by many people, don't do that. He said, I'm an informant. I'll do it. And my boss wants me to. So where are you there? I mean, it doesn't answer the question of whether or not Mr. Strange is an employer under the Industrial Safety Act. The facts of an individual case don't determine this. This is a very obviously tragic, unusual situation. But what is the critical thing here is that the construction management manual gives him very limited authority to interfere with the contractor's prosecution, performance of its contract. And it gives very specifically, it gives the contractor responsibility for the safety of the workplace with very limited exceptions.
What interests me is this notion of limited. Yeah, it was limited. I'll accept that for the sake. Why does it matter that the control was, quote, limited, if the control was enough to have prevented
Well,
the harm that ensued here.
well, the employer
And the
determines.
responsibility and stuff. I mean, it's not just that he had the authority. He was told, you have to correct.
Well,
You shall correct.
it is, again, it is an exigency, you've seen a violation situation here. The comprehensive abrasive authority over the workplace safety was in civil construction. It had hired a safety officer, Hector Choto, who is
Was he missing in
Mr.
action, by the way?
Pardon me?
Do I remember this correctly? I may misremember. Mr. Shoko was missing in action here.
Well, no, he was, he's all, you know, the trial court said that it was undisputed. He oversaw safety conditions at the site, and that's.
No, generally, I understand.
Pardon me?
But not- Generally, I understand. I have this recollection that
Well,
Mr. Shoko wasn't around for this.
Well, he was the safety officer. He oversaw the safety conditions at the site, and that the Superior Court so found. And I don't think there's any dispute that Mr. Choto had that authority to over safety, and he is a civil construction employee. That's right pursuant to Section 9 of the Construction Management Manual, giving the responsibility of civil construction over the safety of its workforce. So civil construction correctly appoints a safety officer, Mr. Choto, and Mr. Choto, Mr. Zelaya
Mr.
testified.
Mr. McKay, I'm not sure that it's helpful to describe what Mr. Choto's job duties are. I just
All right.
think our focus should really be on Mr. Strange's duties, but we've kept you up at the podium for a very long time. My last question for you is on this point of whether or not a litigant can take an end run around the ISA's carve out of the district, right? By suing an employee of the district. I understood Mr. Zelaya's counsel to say that was litigated below and has not been pursued on appeal. And so that has been abandoned and we should take the case as it comes to us. Is that accurate in your view?
Your Honor, the issue that was litigated was whether or not Mr.
Strange was an instrumentality.
But the Superior Court, the second opinion, held that Mr. Strange was an instrumentality of the District of Columbia. That was a conclusion of the Superior Court.
Right. And
This
we
court-
reversed that.
Reversed that.
But on remand, was there an argument made that really you cannot hold Mr. Strange liable because to do so is just to take an end run around the carve out for the district in the Industrial Safety Act?
Well, I mean,
Has that argument ever been made? Has it been abandoned?
Well, we did not abandon the argument. It was, in my argument, it's implicit in the argument that, he's an instrumentality. I remember arguing this.
He's not an instrumentality. We held that. So we are bound by that. And that's not the question that I have.
Yes.
So I'm just asking for an answer. Has the argument been made that you really cannot sue Mr. Strange based on a duty as an employer under the ISA because it completely explodes the exclusion of the district as an employer under the ISA?
Your Honor, I think the issue has been raised. We did not make that precise argument. The issue is basically the scope of the ISA and whether or not, and I certainly when I remember when we argued whether he was an instrumentality, I think that's within the scope of that argument, but it hasn't been abandoned. I think the issue is raised. We did not make that precise argument. I agree. So, I mean, if this court, yes, Your Honor.
I just wanted to make sure I understand your argument on what you say was Mr. Strange's limited control and authority here. The language that I believe just Easterly pointed out and Mr. Fielder pointed out about shall require correction. Your argument is that that is not sufficient to give Mr. Strange the requisite authority and control here because of the other provision that you cited that says that the civil, I forgot the name of the contractor, has authority and a responsibility for safety and on the work site.
That and also the fourth factor in Presley, that CRSS did not normally act directly to rectify safety violations. There are
Right,
two ways.
but here, the CRS and in Presley, they didn't have this language, shall require correction.
Well, but again, that's not direct. You tell the contractor, you've got to correct this. I'm requiring you to correct this, contractor. Otherwise, we're going to maybe take some action against you, like dock you on the contract price or something like that. But I mean, that's not the same as giving a direct order to an employee, telling the employee how to do his or her job. That's not, that a stop work order would be that you say, stop doing this, employee. But when you require correction, that is not a direct order. That is basically, you're telling the contractor, you've got this, you don't have hard hats for your crew. I'm requiring you to issue hard hats to them. If you don't, of course, we'll have some contractual remedies maybe. But that's basically what they're talking about when he's saying require. You require the contractor to do it, but you don't order the employee. You don't interfere with
That
the
sounds
employee.
like exactly the kind of thing the ISA would be interested in.
Pardon me?
Requiring people to wear hard hats sounds exactly like the kind of regulatory action the ISA would have been interested in when Congress enacted it in 1918, right? I mean, that's sort of broad kind of, we want you to impose these safety measures.
Yes,
That's what the statute was about. So if you have that authority, that seems to support the custody or control of the work site.
Maybe that's a bad, number one, the ISA was in a 1941 amendment to a 1918 act. And basically the regulations are promulgated by the board include, you got to wear hard hats. I mean, so basically all the employee, all the contract manager would say, follow the regulations that have been promulgated by, the government. That's basically what it would say. He is not the one who creates that rule. In other words, Mr. Strange did not establish the rule that all construction workers wear hard hats. That's in the regulations. Basically, it's a situation where he can intervene, or if he sees an open pit, he says, or maybe it's hard to think about good examples, but he sees something that's very bad is happening, or a worker's doing something with not a proper equipment. He could just tell the contractor, you got to give this person better equipment to do his job. And that's basically all that Mr. Strange could do.
Is that right? In this case, I thought Mr. Strange not only had the power and authority and obligation to require correction, he also had the power and authority to stop work.
Well, that's just like the CRSS in Presley, exactly like CRSS in Presley. So he has, and this CRSS was not found to be an employer. So Mr. Strange didn't have any more authority than CRSS had, and yet CRSS was not found to be an employer. So basically, the factors are all here in favor of Mr. Strange, just like CRSS. I've detailed them in our brief. Plus, you have all these additional factors that this construction management manual clearly, expressly gives the civil construction, the contractor, responsibility for the safety of its workers. So you have those two combined, and the bottom line is that we don't think this court should not extend the meaning of the word employer in the Industrial Safety Act to include a mid-level employee who's trying to do his job, and he doesn't have any of the authority, the abrasive authority that the entities that have been deemed employers by this court had. So he is really quite different from them. He is similar to the CRSS, and actually has, we have the additional provisions of the construction management manual that give authority, responsibility to civil construction for the safety of its workers. So we would ask this court then to affirm the Superior Court's grant of summary judgment in this case.
Right, thank you, Mr.
Thank you
Chair.
very much.
All right, um, Mr. Fiedler, I apologize if I've been pronouncing your name incorrectly. Fiedler, yes.
I'll try to be swift here in 2 minutes. To the point that about whether this issue, he's just an individual, he shouldn't be held liable under the ISA. It was directly raised by Mr. Strange in front of Judge Park on this last go around of summary judgment. Quote, I'm quoting from page 581 of the appendix. In his motion for summary judgment, the defendant, Mr. Strange, argues that Mr. Strange did not owe a statutory duty to Mr. Zelaya as an employer under the ISA because holding Mr. Strange individually liable under the ISA contravenes the statute's purposes, and because Mr. Strange did not have custody or control over the job site or over Mr. Zelaya. And then on page 583, the court ruled, though the court was unable to locate any decision in which District of Columbia considered an individual's liability under the ISA, then he cites the various cases. The statute expressly includes, quote, every person.
Right,
Quote,
Mr. Fiedler, though, that seems more generally directed to whether or not an individual can be an employer, an individual within an agency, within a larger entity can be an employer. But my specific concern was whether the issue about the carve out for DC had been raised as a reason that Mr. Strange, as a DC employee, why he could not be an employer.
I believe that was raised in earlier iterations. This is gone. There was motion for summary judgment. It was partially granted, partially denied, a motion for reconsideration, then appeal, then remand, then another motion for summary judgment. I believe it was one in the original motion for summary judgment or in the motion for reconsideration of the portion of the order denying summary judgment to the district. Yeah.
We can take a look at the record, but
Yeah.
in any event, it hasn't been raised on appeal at this juncture. Yeah.
So I just wanted to put that to rest. The issue that Mr. Strange's authority is just like that of the consultant in Presley. We addressed it in our opening brief. Practically the entire first argument in my reply brief goes point by point, very carefully pointing out where that is wrong. It is not the case that that Mr. Strange has the same authority as a consultant in Presley because they both had stop work authority. It was way beyond that. Mr. Strange could monitor compliance with safety rules and regulations that the consultant in Presley did not have responsibility for. The ordering remediation of observed potential dangerous situations. You know, I highlighted that in my opening, but not to the, I don't want that to be the exclusion of the other considerations, but that sticks out. That's way more than stop work authority. And, you know, there is an issue. Can we just grant that it's unfortunate that the Congress used the word employer to describe who's, you know, potentially liable here? It's an awkward word. I wish they used the word controller or something else, you know, wrap anything other than employer, because it's just so contrary to what we would normally think to see. This mid-level employee is going to be held to be an employer of somebody that he never hired. I mean, it just sounds weird, but it's a statutory employer. It's got a particular definition, as Judge Glickman pointed out. It's who has custody or control of the workplace or of the workers. And here, Mr. Strange had control of the workplace, not the workers. You know, the means and methods of construction were entirely up to civil construction, not up to Mr. Strange. And if he observed that imminently dangerous situation or potentially dangerous situation. Yeah, he could not tell the contractor how to fix the problem. He could stop the work and tell him, correct it. And it was up to the contractor to figure out how. It's a fine distinction, the same kind of distinction between the contractor had responsibility for the workforce. Mr. Strange had responsibility for safety of the work site. It's hard to tease those apart. They do overlap, but at least in my mind, there is a clear distinction. It's a distinction made by the statute itself. You know, control or custody, either of the workplace or of the workers. So I'll be happy to answer any other questions the court may have.
All right, thank you,
Thank you.
counsel. And we'd like to thank all counsel and parties for your briefs and arguments today. And that concludes our cases for today. We stand adjourned.
All rise.